The joint performance review is called back into session. And, well, you've been in trouble, Mr. Mehdizadegan, if I decided to call somebody else, huh? So, thank you for being here today. So if you'd stand up and raise your right hand. Do you solemnly swear the testimony you're about to give would be the whole truth, nothing but the truth, so help you God? And please take your seat, state your name and your position for the record, please.
Thank you, Mr. Chairman Berry. My name is Abtin Mehdizadegan. I'm a partner with Hall Booth Smith. And just to get something out of the way, I'm very comfortable with Abtin. If anyone wants to just dispense with Mehdizadegan, and I'd say if I haven't.
I've been practicing the Mehdizadegan so much that I'm going to use Mehdizadegan. So
I think my family saw the alphabet and they said, "Ooh, let's just take all the letters. He sounds fun." But if you don't feel comfortable with it, Abtin's fine, and I'm not going to take any offense.
Good. Okay, thank you. So a few questions to get started, and we'd start taking questions from the members. But Mr. Mehdizadegan, have you provided any advice to other members of the board on their testimony for today?
I wouldn't say advice. I've talked to them to make sure, there's a confusion about whether the meeting would be today or yesterday.
So basically you talked about timing of the meeting and so forth, but not anything relevant to the matter at hand.
Not about the content of what they might say.
Okay, thank you. So did you meet with anybody to prepare for today? Anybody on the board? Did you have any meetings or anything?
No, sir.
Okay, good deal. All right, and I'll take questions from the committee. Go ahead. And Senator Dismay.
Yeah, and it's just really, I think you heard some of the testimony. Like I said, you're in a better position, maybe our first two folks. When did your contact with the board about possible, representation begin?
If I may just speak freely and just kind of tell you how this came to pass. Let me just say, I know, before all this, I knew no one on the board, personally, professionally, or otherwise, directly or indirectly. I'd never met Mr. Magnus until December 8th. I was sitting at my desk one day at work. I got a call from a name I didn't understand or didn't recognize. My caller ID, it said Lee Watson. To be honest with you, I was a little annoyed that day because I had a few calls from other folks looking for a plaintiff's employment attorney, and I'm not that. So I get a lot of those type of cold calls. I thought he was going to be another one. Almost didn't answer. I answered, and at the time I was teaching at the law school. I teach employment law. I studied under Professor Terrence Kane. Was the best employment law professor I ever had, and taught me a lot about the law. And I had been teaching for about 6 years. I obviously have a number of constitutional litigations pending, and I got a call from Lee. And Mr. Watson said, "Hey, you don't know me. I'm on the Board of Corrections. We have a bit of a challenge with Secretary Proferi, and it's a unique employment law that has a confluence in constitutional law. Do you know anything about Amendment 33? Would you be willing to consult with me?" And honestly, in that moment, it's not uncommon as a law professor. I get lots of calls to answer questions for the media, and work on pro bono issues, whatever it might be. There's a lot of what I'll call informal consultation. I'm always clear to say I'm not wearing my lawyer hat. I'm wearing my professor hat when we're talking. And I didn't know anything about Amendment 33, but I was curious, and I said, "Look, let me take some time and look at this and see what's going on. I'd be happy to talk to you, down the road." This would have been, in my best recollection, on or about or around November 9, November 10, somewhere around there. Please don't hold me to that date, but I can accurately represent it was in the early part of November, prior to November 17. And so I had done some research. I looked at it quickly. There's an Encyclopedia of Arkansas article. I did a little bit of Westlaw research, and to me, it was. And please take no offense to this. I understand the awkwardness of the fact that I challenged a law that y'all passed by a substantial majority, and so I appreciate the awkwardness of it. And please don't take offense to what I say. I'm not trying to argue or castigate or anything. I truly want to be here and be respectful and answer your questions to the best of my ability, and that's what I will do. But I looked at it quickly, and I thought there was some incompatibility in the laws that were passed. So the law continued, even after amended before the challenge, continued to have the Secretary of Corrections position be approved or final approval by the Board of Corrections, which didn't make constitutional sense to me because of that incompatibility if it's the governor who has the final say over the person or the management of it. And so it just didn't make sense. And so I said, I had a few conversations with Mr. Watson. Maybe, when I say a few, maybe one or two. It was mostly, hey, I've read Amendment 33. Yeah, this is interesting. But there was no action. There's no call to action. There was no concept of hiring me. I was a little, frankly, suspicious of. I didn't know who he was. I'd never met him before. I had another lawsuit against the state, and I didn't know if he was a friend of someone who was calling to try to get me to something. I don't know. But I talked to him, and I was struck by how dutiful and respectful he was of the Constitution, and that's really the heart of our conversations have been. He's a constitutionalist. I'm a constitutionalist, and I took an oath, the same as everyone here, to uphold and defend the Constitution. As a lawyer, you can appreciate to take up the cause of the defenseless and the oppressed, to not reject matters personal for myself that might call me into meetings like this, and I really appreciated that we have government actors who care about the Constitution in a way that I'd never really truly seen before, and that was kind of the heart of the conversation. And then on November 17, the press conference occurred, and I don't want to pick arguments or make arguments, but just a couple observations for you. As a matter of employment law, Secretary Proferi was at and spoke at this press conference, castigating in some ways the board to which he is at least answerable. But here,
practice. I want to get back to let's stick to the timeline, not the narrative, because that's what I'm asking about. Sure. And I want to be really clear with you about my position with you. Okay, like you are in a very different position than every member of the board that comes up here, because what they have done is sidestep the laws of the state of Arkansas. It's not necessarily your responsibility to be the one that confirms if you're reaffirming a contract or not. That was their responsibility to look at it. And so, like I said, I don't want you, from my perspective, to think that I don't need to litigate any of the case. I don't need to litigate why you felt you were compelled to go on, and take him on as a client. I can be for all of that. I mean, I think financially it was probably beneficial. But, in the end, if those things align, then you got a home run, right? Your beliefs in your pay. But I would say, so I'm at November 9th, got a phone call. November 17th, you watched a press conference. In between those two dates, there were maybe a couple of conversations with Mr. Watson. Were there any of those by email? All phone calls? I
don't believe so. I think phone calls, the first time I met Mr. Watson in person may have been, please don't quote me on this, it may have been either like Saturday or Sunday, or I don't know, some day during the week, I'm not sure, between, I believe, November 17 and November 20, and I could be mistaken about that. It may have been some action after that.
You have more information than anyone else so far. Sorry, so we're now at November 20th.
November 20 is the date on which Chairman Magnus issued his letter to the governor, inviting the governor to meet and speak about these issues to avoid the constitutional conflict that also painted the history of Amendment 33. I had a hand.
So you assisted
I had a hand
Mr. Watson
in reviewing and making some kind of nits. I was the editor-in-chief of the law review, so I made some nits and some edits to the document.
But that was pro bono work. You don't have any contract employment.
No, not at all. Just as, again, law professor interested. And again, all Mr. Chairman Magnus's content, just some revisions and edits that made it flow a little better. That was November 20. I must have had some type of, I'm certain I had some phone call with Lee, Mr. Watson, excuse me, between November 20 and December 8, which is the day on which my engagement agreement was signed.
Yep.
And now that I think of it, maybe it was prior to December 8, right before the December 8 meeting, where I met with Mr. Watson over pizza in person. I really just wanted to see who he was face to face, because I didn't know him. I don't like to take on clients over the phone, so I'd like to have at least some, just know who they are. I was never the conversation that Mr. Watson and I had was, again, just kind of pro bono, kind of just interested, kind of watching this. And then there were different events, maybe in the media, or different statements made. I think the Attorney General made a number of statements that, from my perspective, from an ethics perspective, very interesting, because the Attorney General actively, even to this day, actively represents these folks. I'm not aware of any state, ever, where you can castigate your own clients like that and then sue them. And so I think we may have had conversations around that between November 20 and December 8, just kind of following it along. And then I believe around that time, the December 8 timeframe, the governor had given Secretary Proferi some directive to open additional space up before the board's deliberative processes had concluded on whether or not that was an appropriate decision to make.
Okay.
And at that juncture, I took an old engagement agreement that I had used for other public entities, and I will tell you, I have represented every branch of Arkansas government in my practice, every branch. And so I took the exact same engagement agreement, and I made some minor modifications to it. In part, number one, specifically remove language around sovereign immunity, intentionally, because I expected, to be frank with you, I expected that we would be here at some point. It's not lost on me that.
I understand. You're suing a board on behalf of a law that we passed. I get it.
Y'all
and we're not
passed,
litigating
the
that.
governor signed.
I'm only care about timeline. I don't care about the narrative.
Yes, sir. Okay. And so on December 8, I had known that there was going to be a board meeting that day. I didn't know, and I had not spoken to anyone other than Lee. I may have spoken to Benny that day for the first time. I wanted to know what he was all about. I Googled him, and that was the extent of my knowledge of Mr. Magnus, or Chairman Magnus. And I think we may have met face-to-face that day before the meeting for the same purpose. I really just wanted to know his story, who he is, how long he's been with the board. Met that day. No one had promised me anything. No one had said anything. What I was told is that we'll see what happens. They hadn't talked about hiring an attorney. As I understand it, as a board, they had several conversations around, prior to all this, around Secretary Proferi's performance deficiencies. And I think those conversations always led to the point of, what do we do about it after these laws were passed? And that's why I made the engagement agreement readily available to them. You'll notice it doesn't have a date on it, because I think I just gave it to Lee and said, hey, if this is something you'll ever need, here it is. You can consider it. It's at a discounted rate, by the way, and there are all elements of a contract are in my engagement agreement. An engagement agreement
I'm not worried about
is
your
absolutely a
engagement
contract, but
agreement.
there is an hourly rate, and it's a discounted hourly rate. My normal rate's $350. I do a lower rate for public service work like this, which is a rate that I think this body wouldn't ordinarily have any
And
concern
if you
with.
just answer the senator's question.
Yes.
We don't need to just keep it succinct. We don't
Yeah.
need the narrative like the senator said.
And Joe, so to be specific, so you understand where I'm coming from, and we can pursue a completely different path, and this is not my goal. My goal is, I've had testimony so far, we're going to have continued testimony. I believe that the proper protocols weren't followed to even hire you. Is that your fault? No, I don't believe that it is. So my basic questions are, and you've given me the timeline, I think that I needed to get to where I am, so we're good at that point. We're at December 8th.
So December 8th is the date on which the board goes into executive session, speaks about Secretary Proferi's employment, comes out of executive session, and makes two votes. One vote to hire outside counsel, and the second vote to hire me specifically.
A 3-minute meeting.
Pardon?
It was a 3-minute meeting.
If that's your representation.
No, it's not mine. It's the minutes of the. Now, it would be awful if they're not true and accurate, but that's what the minutes say.
I was there, so it wouldn't surprise me.
That sounds good. About right. Yeah.
Sure.
Okay.
I think on December 8th, the Attorney General's office, and particularly Deputy Attorney General Dorley Chandler, called Mark Colbert, the compliance administrator for the Board of Corrections, and advised of her opinion that the board was violating 2516 702. On December 11, We received a letter from the Attorney General issued a letter, and I think it was sent to me as well, more or less saying the same things. On December 14, I issued a letter to the Attorney General advising of two things. Number one, of the board's position relative to 2516-711, and of the fact that the only person of whom I'm aware who's ever actually violated 702 is Dorley Chandler in a case titled 2600
I do
Holdings.
not need
I'm
the
trying.
narrative.
I'm just trying to give
I need the timeline.
and that's the timeline. So that was December 14.
But I don't need the narrative behind the timeline.
Sure.
What I am mostly interested in, because, and I'll just put it this way, so it's very succinct. I mean, and we're on the same page. It's been told to me and represented to me that there is no correspondence between you and Lee Watson or really anyone else with the board that didn't happen by the phone. So thus, none of it can be provided to the legislature. There's an engagement letter and a few other little things that happened. But as far as the conversations, which I'm really interested in, is, how did Mr. Watson come to pick you? How did that conversation play out? Did you meet with the board that day on December 8th, or did they meet in a 30-minute executive session, come out of that and decide to hire you in 3 minutes? And so you're also representing there was no communication other than verbal between you and the board prior to you being engaged as their attorney.
I want to answer your question without providing a narrative.
Thank you.
And so, from a timeline perspective, I'll put it this way: if there is any written record of any communication that I've had with the board or its members individually, it has been turned over.
Okay.
At the same time, I represent a number of public entities, and I understand the extreme costs associated with complying with FOIA requests. And I also understood that it would be saving taxpayer dollars if we were exercising appropriate data hygiene that I've learned from Attorney General FOIA presentations. And
Okay.
so, to the extent that there were records, I'm not suggesting that we never emailed. If there were any, they were deleted. And it saves money so that every time I get a FOIA request, which has been substantial, 10 so far from the Attorney General alone, I don't have to go back and pull a history or years worth of these documents. And that's my standard practice.
So on your side, you would have no documentation because you have a practice of deleting the emails. Is that what you're saying?
Correct.
Okay.
As is the common practice of every government attorney and participant of whom I'm aware.
That's enlightening. I had no idea, and that's good to know. Okay, so you are not able to provide any backup then to the questioning. You don't have anything in record, so when it comes time when we're talking to the members, we'll make sure to ask those questions.
I don't want to paint with such a broad brush, Senator, respectfully. I do have records, and I'm not certain that you have requested all of them. I am certain that the Attorney General has, and all of those records have been turned over to the Attorney General, and I believe all records that this body has requested have also been turned over. So I haven't gone back.
Mine were never of you. Mine were of the board members who said they had nothing.
Pardon?
So mine were of the board members through legislative counsel who said they had no records. There are no records of your communications of any kind or how we led ourselves up to the hiring process of you, other than some board minutes and a letter of engagement and those types of things. And so, if you don't have them, that's fine with me. It's a continuing question I'll have for additional members as we move through.
If there are records, they were turned over to the Attorney General when they requested them, or whomever requested them in a FOIA request, and I assume that that's the same information that was turned over to you. I also did not go back and cross-reference the thousands of pages that were requested by each body at different times.
No, mine were pretty simple. So, again, let me just reiterate, I asked for nothing through the Attorney General's office. I asked through Legislative Counsel, which is, our vehicle to do such things. Okay, so, but you're saying there was no written communication, just one more time, because I think you told me there was nothing that's FOIAble because you delete them. Was there any written communication between you and any board members prior to December 8th?
If there were any written communications, it would have been only between me and Mr. Watson.
Not if, were there? I understand.
I am certain that there were text messages. I am certain that Mr. Watson and I texted.
Okay.
Hey, do you have time for a call?
Perfect.
And I would delete those things.
Right.
And I.
Absolutely. I'm not asking you. You understand? I tried, and I'm not being articulate. I'm not saying it well enough. You do what you do. Okay. It is not your responsibility to make sure that board members act like board members and act appropriately and follow protocol or even follow procurement law. That is not your responsibility. And so I think you heard in the line of questioning earlier, that's what I'm mostly interested in. And so my question is just a simple yes or no. So now there probably were some text messages between you and Mr. Watson.
What I would consider to be kind of ministerial type, hey, do you have time for a call? Something like that.
Okay.
But again, to the extent that there were those communications, and I think there were, just on kind of coordinating, like, hey, can you talk to me? Those would have been deleted.
And like when you did the markup for the response to the governor's press conference, I think that's what you said, that you helped kind of mark up that document a little bit. How was that handled? Did y'all trade communications back and forth, or?
I think I called Lee, and I think we spoke over the phone.
Just called and had him red line through and said this needs to come into play and this doesn't. So he sent you, though, a copy of it so that you were able to see it?
No, we met for pizza at one point, and he had some copy of something, and I think I provided some notes to him.
And so he gave that to you. He gave you a copy of the document.
I think it was like a lot of like copy and paste from like Arkansas Encyclopedia. Like it just kind of it looked like a data dump to me. I don't really know. Just kind of some different pieces of information.
All right, I'll leave it to Mr. Watson. I understand. I appreciate the fact. I mean, you're forthcoming. Your policy is to delete emails, texts, and all those things.
Yes, sir.
So they're not subject to FOIA. I completely understand. All right, thank you for your time.
Thank you, Senator Dismang. And Mr. Mehdizadegan, how much is the Department of Corrections paying you to be here today?
The Department of Corrections is the defendant in the lawsuit. I don't represent the Department of Corrections, and so the first answer to your question is nothing. If you were asking about the Board of Corrections,
well, I mean, Board of Corrections, you know what I mean.
same. So far, what we're here to talk about is I've not been paid anything yet. My rate is $285 an hour.
But is that what you're billing the Board of Corrections right now for you to be sitting there as $285 an hour?
I think it'd be appropriate, General Berry. I think that'd be fair. I had billable work that I should have been doing and could have been doing today, but instead I was asked to come here and talk about.
So what time did you start billing?
Pardon?
What time did you start billing the Board of Corrections?
It's actually funny. I wrote down on my sheet here 1 p.m. Because I think that's fair. That the time I'm sitting here answering your questions. So until you're done asking me questions, I will keep the meter on. And it's something that I think if the board has a problem with, they can ask me to strike it or just strike it from the bill, and I won't have a problem with it. I think it's fair that I be compensated for the time that I spend representing the Board of Corrections.
So did you bill, are you going to bill the Board of Corrections for the time that you spent preparing for this meeting?
To be frank with you, Representative Berry, General Berry, I haven't spent much time preparing for this meeting.
Okay. Senator Hammer.
Thank you. Good afternoon. Question with regards to that. Based on the contract that was presented to ALC that was not authorized or approved, do you then intend to go back and adjust your contract amount?
Without offering a narrative, can I provide some explanation that I think would help everyone understand?
If we can do it in about 2 minutes or less, would be great. Yes, sir.
I will. So my contract is my December 8 engagement agreement. That is the contract. It was supplemented on December 22 after the Attorney General sued his own clients that brought this brought the second supplemental agreement to the fore. What I want this body to appreciate is that it is impossible for me to understand or to be able to look into a crystal ball and to tell you what the litigation is going to cost. This litigation, and frankly, you have certain procurement rules that don't apply if the measure would cost under $70,000 or $75,000. This lawsuit very well could have and should have cost under $70,000 if the Attorney General was not, number one, attempting to drive this narrative about the cost. That's what's happening. They have filed motion after motion after motion after motion, it's like going back to the Magna Carta to try to explain the law in some of these filings for them. You know, there is a statute, 25-1106, that defines what a constitutional board is. That statute defines the Board of Corrections as a constitutional board. Probably have devoted 20 pages each on what that means, constitutional board. It's not that hard. And so I cannot sit here and tell you what this lawsuit or this representation will ultimately cost. It's like Newton's laws here. For every action, there is an equal and opposite reaction.
Okay.
I have endeavored at every opportunity to ask the Attorney General to streamline this, to stop fighting, to reach agreement so that we can avoid unnecessary fights.
Okay, I tell you what, dude, let's stop here because you're billing us by the hour and the clock is running up. So let me just ask you some very pointed questions. Then under the current contract that you have, I'm not sure how it is that you're going to be able to bill on the basis of the current contract because of the scope of which that contract was authorized by the board to do. So I think we might have some issues there, number one. And then the second thing is, in your testimony, Senator Dismayne, I understood you to say you were, proficient in dealing with, government entities. There was a memo that was sent by Mr. Brown, I think, advising the board that there were some concerns about, the contract and that it didn't necessarily align with the law, and that was on January 19th. Were you privileged to that memo, number one? And number two, did you respond to the board and say, hey, you know what, there's a point here? I mean, you acknowledge that you're proficient in it, so in a couple of minutes or less, could you answer the question, please?
I became aware of that memo, I believe, a few days after it was issued by Mr. Brown. I know it was dated January 19. Also dated January 19 is Judge James's order finding that Section 25-16-711, which says when there are disagreements with constitutional officer and the Attorney General, they can hire special counsel to resolve the matter by litigation, and that Judge James found that statute applied. Mr. Brown's analysis effectively parroted what the Attorney General's arguments were. That is not surprising to me, because Mr. Brown is represented by the Attorney General as a defendant in this lawsuit. And so I don't agree with the premise of the procurement analysis memo. I'm not here to argue or debate that. I think there are a number of questions. For instance, 711 has a repealer clause. It was passed in 1975. 702 was passed during the Great Depression. The Secretary of State of Arkansas has argued to a court that 711 repealed 702. And so there's a substantial question of whether 702 is even lawfully enforceable or the law of Arkansas to this day. So there's a fundamental issue in Mr. Brown's analysis there. There's a separate issue, and I don't mean to disrespect this body or the power that you have. And that's what governments are all about. It's about the allocation of power. This body has the power of the purse and the accountability of being able to call folks up to answer these questions, and that's what the legislature enjoys in its exercise of power. In that specific way, the Attorney General has opined, it's opinion number 2007-007, that...
Could I interrupt you and just say what we're going to end up doing is agreeing to disagree. You have an opinion about Mr. Brown's memo. All I needed to know was that you were aware that that memo had been sent, and you did not advise the board differently after you became aware of that memo. Yes or no?
The only thing I would have advised, I think this is my advice. I'll
just yes or no, that's all. You are aware of it, but you didn't give the board direction that we need to stop. Is that correct?
I don't know that I can answer it with a yes or no. Can I have 20 seconds to answer?
20 seconds, yes, sir.
So number one, I was aware of the memo.
Okay.
Number two, I don't believe that I advised the board one way or the other about the memo. It's not my scope and not my place. I'm not a procurement expert, and I wasn't hired to be one. I have a very specific and limited defined position here as special counsel, so I defer those questions to their staff and the people who are experts there. But number three, I do disagree with it, and I think to answer your question truthfully and forthright, I believe the only thing that I have said to the board is that I don't have a substantial degree of confidence that this process will result in my bills being paid, and that there is still another branch of government that might have a say about that.
Okay. All right. Thank you for your respectful dialogue. Thank you.
And to follow up on my question a minute ago, so the Department of Corrections is paying, the Board of Corrections does not have an appropriation. And you may want to keep your comments a little succinct anyway, because the scope of work from your own letter of engagement does not cover paying you for appearing in front of a joint performance review for the Board of Corrections. So did you know that?
If you'd like me to take a moment to
Well,
read
no,
the engagement agreement.
obviously you did not know that because the way you answered my question earlier. So I'm going to defer to Representative Gazaway.
Thank you, Mr. Chairman. Thank you, Mr. Abtin, for being here today. Couple of questions. I want to go back to how this all started. So it sounds like prior to the November 15th press conference, you were already engaging in talks with the Board of Correction. Is that right?
No, Representative Gazaway. On the November 17th press conference, prior to that, I had engaged in academic discourse with Lee Watson specifically and only.
Okay. What did that consist of?
As I said before, he told me about Amendment 33 and the concerns they had around Secretary Porfiry, former Secretary Porfiry, and was interested in if I had opinions about the incompatibility between the statutes that this body passed and the Constitution.
And did you have opinions?
I didn't know anything about it at the time when we first spoke. After he called, I was kind of interested, did some Googling, did some research. I spent a lot of time. It's more than you want to know, but my wife was pregnant, and this is my fleeting last couple months of time to be able to stay up late and to do these things. And so I was just academically interested and researched and read some material after that initial conversation.
Okay. And so you formed opinions, and I take it that you related those back to Mr. Watson.
Yes.
And you knew Mr. Watson, of course, was a member of the Board of Correction.
He identified himself as a member of the Board of Corrections, but to be more clear, he was, in my view, asking advice on how he individually should proceed given his more specific duties as an attorney. And so it wasn't, I think I understand the nature of your question. It wasn't to advise the board on anything. I think he was interested, curious. The way it was presented to me just seemed curious, seemed interested, and wanted to know if there was some collaboration that I'd be willing to have with him in that dialogue.
Okay, so you've represented entities of this state before. Is that correct?
Correct, yes.
May still represent them now. Do you represent other entities of the state now?
I don't want to get into any client confidences.
Okay, well, so you put in the certification that you submitted along with the contract, the services agreement. There was a mention that your firm represents UAMS, ADFA, and then you're advising the Board of Corrections. Is that correct?
Correct.
Okay, so, I mean, just to break this down, so you're a licensed attorney, obviously. You kind of cast yourself as a law professor, but
I don't mean to interrupt you. I don't mean to paint a false picture. I'm an adjunct, and I get paid, I think, like $2,661 per semester to teach a 3-hour class.
What class do you teach there?
Employment law.
Okay, so you teach one class at the law school, but otherwise you're an attorney engaged in the private practice of law. Correct?
Yes.
You routinely have, and your firm represents entities of the state, correct?
Different branches or entities or boards or bodies, etc. Yes.
Okay. You have a member of the Board of Corrections who's coming to you asking you questions about Amendment 33. You're formulating opinions, doing research, and providing him answers. And you do, and the way I've heard you couch it thus far is that you did that as this purely academic exercise because you are, of course, a law professor. I mean, do you understand how absurd that sounds when you represent other entities of the state and you're contacted by a sitting member of a state board for advice about issues involving state government? That this was some academic exercise as a law professor? I mean, would you have us believe that?
Yes, because it's the truth. It might not be the answer that you want to hear, but that's the truth, Representative Gazaway, respectfully. I'm not here to paint, and when folks call for those types for advice, I generally want a retainer agreement. When folks call to collaborate and discuss, and at that level, which it was, because I obviously was well aware that he couldn't hire me, he had no authority to do so. The board would need to make those decisions as a collective. In that way, very much so, it was my choice to invest my free academic time into that process. I care deeply about employment law issues. I'm kind of a nerd about it. I think it's the most important area of law. And I was fascinated by the discussion. He didn't give me research assignments and ask me to research questions for him. It was more about getting caught up to speed to understand the nature of the Board of Corrections, its history, and the foundation of Amendment 33. So I don't want to misrepresent to you what those initial discussions were. I viewed them as very academic. And if I don't know that I can answer it another way, that is what I felt in my heart and soul.
So when you think about the formation of an attorney-client relationship, I mean, you have someone who's asking you advice, you're providing them with research and opinions. Do you believe that you formed an attorney-client relationship?
I didn't provide advice or research. In some ways, perhaps that could be more of I understand what you're saying, certainly more of a concern if you're dealing with a layperson. But Lee Watson is a very well-practiced attorney and has a substantial degree of experience. And so in some ways, for instance, and I won't go into it, but Representative Yazaway, I could contact you and ask you and engage in ethics consultation advice, and that would be a perfectly reasonable thing that does not create an attorney-client relationship.
I just wanted to get your opinion about whether or not you believe, in this instance, that you formed an attorney-client relationship.
I believe my relationship with the board was formed on December 8th after they executed my contract.
Okay. I have a few more, Mr. Chairman.
Go ahead, please.
Appreciate the latitude. Thank you. So it sounds like there was some continued communication that occurred in and around the time of the November 17th press conference. Is that right?
Yes, between
you and members of the board?
No, between me and Lee Watson.
Okay. And what was that about?
It was about, number one, the press conference. I've never seen a lawyer, for instance, go on TV and blast their own client and said there were failures. As a matter of legal ethics, Mr. Watson and I had several discussions about the Attorney General's misconduct in that respect. And so we had several conversations about that. And then those conversations continued along those lines because the Attorney General was quoted several times in the papers after the fact, before December 8th, castigating his own clients again. And so we had more conversation about his legal duties as a lawyer under Rule 8.4 to report misconduct to the Office of Professional Conduct.
Okay. So once again, it sounds like you're providing some kind of legal advice to Mr. Watson.
Not advice at all. Mr. Watson is a lawyer in his own right. I think he wanted a sounding board, and we engaged in those discussions.
Okay. I guess, let me get to the point. What's really hard for me to understand is you supposedly were hired on December the 8th, right?
Not supposedly. I was hired on December the 8th.
Okay. You were hired on December the 8th, according to your testimony, and you billed over 8 hours drafting, or 6 hours drafting a complaint on December the 8th.
Yes.
So Mr. Magnus testified earlier that you were just hired to give them employment law advice. And on the very day you're hired, following a 3-minute public meeting, you're drafting a complaint and spending 6 hours on it.
So if I could say two things. Number one, on the 3-minute meeting, I have nothing to say about that. That's the board's deliberations. My understanding is that they had months of internal discussions, appropriate executive session discussions regarding Joe Porfiri's employment. And so it wasn't just, I think we're not writing on a blank slate. That's one point that I want to make. Number two, I stayed up very late that night because I expected that this would get hot quickly. Chairman Magnus identified a constitutional crisis. In my research process, I wanted to become more familiar with the specifics. And so drafting the complaint was, it could be called research. It was the document, the ultimate production or the ultimate work product they ultimately created based on the expenditure of time that day. But I left that meeting and I went to my home office and I worked. I didn't see my wife that night. I worked up until, I think, frankly, past past midnight. So every minute of my time and my team's time that's represented on those billings is accurate, and they were justified. We spent an inordinate amount of time on nights, weekends, working on this. One of my associates, from December 8th onward, took only Christmas Day off. The day my daughter was born, on December 28th, I was working from the hospital for the board. And the day I took her home from the NICU, on January 4th, I was in court. I left court and went and picked my wife and daughter up from the NICU and drove them home. Every minute.
And,
I want
excuse me, Mr. If we could do away, your daughter, the hospital, the NICU, and all that, it's not relevant to the discussion. So just answer Representative Gasway's question and then move on, okay? We'll get through this a lot faster.
Respectfully, Joe Barry, I will do my best to do so. It is relevant to me. It is we're talking about the expenditure of my time, and I want you to know that every minute was accounted for and appropriate.
Okay, look, and I appreciate that. If this were a trial, I would object that your answer is not responsive to my question. However, we're not. The point is, and the point that I was making was that it seems as if there was very little discussion when I listened to the testimony prior to December 8th when you were hired, yet on December 8th you're spending 6 hours drafting a complaint, which I find hard to believe could happen unless there had been, in fact, extensive discussion about what the subject of that complaint would be, and so on and so forth. And I'm not interested in your opinion in that. That's the statement. And I just find it hard to believe, and I'm entitled to that opinion. So that's one. Let's go on to the contract and the markings that were made on the contract that was submitted to the state. You made markings on a standard form agreement that was submitted to the state for this services contract regarding sovereign immunity, didn't you?
I'm sorry. My contract is December 8th, and I want to be clear about the terminology, Representative Gasaway, and I'm trying to answer your questions as respectfully and as directly as I can. My contract is December 8th and December 22, the engagement agreement and the supplementation to it. On March 5th, late in the evening, and really on March 6th for all practical purposes, I get this document, and I'm told to sign it. I looked at it, and I had a lot of questions that I heard all of you ask too. What RFQ? What bid? What are they talking about? These are things that didn't make any sense to me. And again, like I said, I've represented the state in every branch of government before. I've never gone through this process ever. It did not make sense to me, and I did not want to misrepresent anything to anyone. When I received that document, I was in the middle of union negotiations that day. I took to leave that to come deal with this because I was told it had to be done that day. And I had a lot of questions about it. And I had, more than that, a lot of problems with what it said. For instance, the defendant, the Department of Corrections, was initially labeled as the party that I would be engaged with. They're a defendant. I cannot represent them. They would be the person who'd be approving the billings. I've never heard of the defendant getting to approve the plaintiff's attorney's billings. And on the changes that I made, I want to be very clear about this. My engagement agreements did not reflect or recite a waiver of sovereign immunity. What I made edits to, the revisions, they're not alterations, nothing that was submitted to I don't know what was uploaded to the portal or by whom. I got a document to sign, I made edits to it, and I sent it back in. That's a standard practice for an attorney, but what I wrote, let's be clear about what I wrote on the document. I wrote, if applicable, next to sovereign immunity. And it's really not up to us or to any lawyers or to anyone to suggest, you couldn't, let's just say, Representative Gasway, you agreed with me that we shouldn't have sovereign immunity apply here. We could have any contract that says that. It will not matter because the Supreme Court ultimately gets to make that decision. What is unique here is that, again, for sovereign immunity, it's a vestige of monarchical tyranny. And so it's the idea you can't sue the king. Well, this is a lawsuit between one constitutional body and other constitutional officers. So I don't know whether sovereign immunity really applies here. And so I thought, if applicable, is a fair compromise that didn't really alter or change anything. It either applies or it doesn't, and we could agree or disagree all day whether it should or shouldn't. At the end of the day, the Supreme Court makes that decision.
Okay, the question was this. This is a standard State of Arkansas services contract that is submitted in instances like this. It's a standard form agreement, and you made your own markings on the standard form agreement that was submitted through this process, didn't you?
Of course.
Okay. And some of those relate specifically to the issue of sovereign immunity, as you've discussed. And your markings were if applicable. And so I guess my question to you is, do you not believe that the court has answered this? I mean, question very clearly about sovereign immunity and the state's inability to waive sovereign immunity?
I don't think the Supreme Court has ever addressed a situation quite like this one, where the statute, there are two things. If you really want my answer, there's some nuanced legal understanding to it. I was trying to get to it, but
let me ask you this. Are you familiar with the Andrews case?
Yes.
Okay. And you know, in the Andrews case, the Supreme Court quoted specifically, "We conclude that Nelson Brothers, Fairbanks, and the Arkansas Department of Human Services are the correct precedent for this court to follow in its conclusion that the General Assembly cannot waive the state's sovereign immunity pursuant to Article 5, Section 20. To the extent that other cases conflict with this holding, we overrule those opinions. Further, this court has held that suits subjecting the state to financial liability are barred by sovereign immunity, and plaintiffs like Andrews with these causes of action, quote, have a proper avenue for redress against state action, which is to file a claim with the Arkansas Claims Commission," end quote. That's clear. That's existing Supreme Court precedent involving a board and an employee. That seems to be clear. Is that unclear in some way?
Representative Gazaway, I don't know that I'll change your opinion, but I'd like to explain mine, if I could just have a moment to do so. Number one, Andrews has been walked back a bit. Number two, this is a unique situation involving an intergovernment fight between two different branches of the government. And so the idea of sovereign immunity has a unique, it's just a question that's never really, to my knowledge, been answered. Number three, the statute, 711, says shall be paid a reasonable compensation. That question has never been answered by the Supreme Court. I think it's something that we need to understand whether in this intergovernment dispute, the Andrews position, which has been walked back by multiple decisions since then, would continue to apply. And the final part of this that I want to make clear is, and if you can refer to the Attorney General's opinion letter 2007-007, and it stands for the proposition that with respect to constitutional bodies under Amendment 33, while the legislature controls the power of the purse, that is to a point. And so I think the Attorney General's conclusion in that opinion is that you couldn't, for instance, completely defund the University of Arkansas. And by extension, the legislature wouldn't have the authority or the power to completely defund a constitutional body in such a way that would prevent the Constitutional Board from exercising its constitutional duties. That's effectively the thesis or the premise of Representative Westerman's lawsuit involving the rates of congressional pay at $174,000. In the same vein, Representative Gazaway, if you accept the premise of the 2007-007 opinion letter, if the legislature can't accomplish directly the defunding, it can't the Attorney General opines that it can't indirectly accomplish the same ends. And so, for instance, if a procurement rule or a statute that says the Attorney General represents everyone would apply to such an extent that it would impede on the board's ability to perform its constitutional duty, then I think that there is a fair argument that sovereign immunity wouldn't apply there either. And again, these are very nuanced legal issues. I was attempting to maintain the status quo, and just that, if applicable. And so I don't think that really changed anything. The choice of law provision of the engagement agreement said that Arkansas law would apply without respect to conflicts of laws issues, and I think that that's consistent. I think the revisions I supplied to the ratification document on March 6th are completely consistent with my engagement agreements.
All right, that's all. Thanks.
Thank you, Representative Gasway. And I believe it was Rick Crawford in the lawsuit, not Bruce Westerman. Is that correct?
After I said that, I'm so sorry. You're right.
Okay.
I'm sorry.
Senator Gilmore.
Thank you, Mr. Chair. And I want to circle back to that too. I mean, that sort of is a big misspeak in invoking a sitting congressman who didn't file a lawsuit. So thank you for clarifying that.
To Representative Westerman, please accept my profuse apologies if you're listening to this. I did not.
Yeah, and that's federal litigation as well. So, we've heard throughout this discussion that you did alter the contract. You admitted to that.
No, sir.
No to what?
So, Senator Gilmore, a contract, as you heard earlier, requires offer, acceptance, and consideration.
Okay.
At that point, what I had a contract. That's on December 28 and December 22.
That was an engagement letter.
That's a contract, sir.
Respectfully, it's an engagement letter, and you called it as such in some of your testimony.
An engagement agreement is a contract, Senator Gilmore. What I received on effectively March 6th, was an effort, I believe, driven by the defendant to change the terms of the agreement to which the board and I had already entered into. I didn't make changes to a contract because there was no signature on that contract at that time. What I had was a proposal, an offer, and I made a counteroffer.
Was your client aware of that?
I think you heard testimony from Chairman Magnus that he did review the revisions I supplied. However, this is a unique circumstance where, again, the defendant in this case, the Department of Corrections, is attempting to tell us how to get on with the engagement. And I want to, if I could, just clear something up.
Well, if you would just answer my question, if you don't mind, please.
So, I forwarded the document to. If you read my email, it's very clear.
I have, yes.
I forwarded it to Ms. Gray and asked her to send it to Mr. Brown, the defendant. It is not my duty, as I believe Senator Dismang said, to educate Mr. Brown or anyone else about procurement law, and I would have expected that Mr. Brown would have, read what I sent and looked at it. It was very clearly not an execution copy. It was intended to be, I think, the starting point of the discussion. I expected to receive a document back that was edited to conform to the provisions that I had.
Edited by the defendant?
Whomever is guiding this process, who's telling us to do it, by Office of State Procurement, whomever is involved. I knew very little. I got an email on March 5th, late in the evening, really read it on March 6th, told me to sign this thing. That's it. So I don't have much insight into this procurement process. But I did not alter a contract. I made...
Well, I'm sorry.
As a practicing lawyer, I revise and counteroffers frequently, and that's what I did here. I did nothing different from my standard practice.
Okay, if I may, then explain to me the difference, if you would. I'm not a lawyer, so I'm not a sophisticated party in these instances. What is the difference
between
altering or not altering?
Altering
because if I may, you do admit to adding text into the standard services agreement which signed supersedes all other agreements.
Right. And so altering something, I think the focus of the word, I don't mean to get semantic with you, you mentioned a contract. Again, the contract is the offer, acceptance, and consideration. I made counter revisions to a standard form document, which I do all the time, in a way that I intended to not gain any advantage or change any of the status quo, to simply maintain the status quo because there are very complicated constitutional issues undergirding all this. I did not want to damage the board's position in any litigation by this document.
So, having said all that, there were changes made to this document, which you, I guess, anticipated your client to review.
I anticipated before my client would review it. the Board of Corrections, they're experts in corrections. They're not experts in procurement. They have people for that. And so I expected those people to do their jobs. And so my email was a notification to them of the document that I had sent.
And what did your email state?
I can read it to you if you'd like me to.
Please.
I believe it said, please see attached.
Okay.
And
I believe that's what it
please-
said as well.
And then please send this to Chad Brown.
And I believe that's what it said as well.
And I didn't want to move from a ministerial discussion about, let's say I'm suing the Department of Finance Administration. I still feel very comfortable from an ethics perspective going to get my license plate tags from the Revenue Office. That seems reasonable to me. In the same way that when Mr. Brown called and asked me what number to put in the fee section, I felt comfortable in providing that ministerial answer, which was $200,000. I did not feel like it would be appropriate ethically for me to sit and provide a substantive legal explanation to Mr. Brown without the Attorney General's discussion. And frankly, my suspicion is that the Attorney General was telling Mr. Brown what to do the whole time, and it very much involved in it. And so I didn't want to cross any lines, and so I thought from an ethics perspective that the most appropriate thing to do would be for me to send that email as it was. And I expected that I'd have an opportunity to call Mr. Magnus or anyone else before anything was signed. I did not appreciate that there wouldn't be an opportunity for Mr. Brown to submit a finalized execution copy or something else. And I certainly had no idea that Mr. Brown or whomever uploaded anything to this portal to the portal for this body or any other body to review. In my view, we were still engaged in that discussion.
All right. So if I may get back to the question here. So your duty, you're right, I don't think your duty is to explain to Mr. Brown, quite frankly, anything, given the circumstances that we're dealing with today. I think your duty would have been to explain to the board members that you purported here to represent. You didn't do that, by all indication, what we have in writing and email. If that did take place, how, when, and where?
It did not.
Okay.
At that time. Since then, there's an email that I think you already also have.
I've read it.
That has that provides an explanation.
And I heard your explanation at the board meeting as well, where you talked about a lot of things. So is there not some duty that you have then to articulate or to lay out the reasoning at the time you send the contract back with substantial edits, even edits made to areas that are, quote, non-negotiable in that service agreement, things that, quite frankly, are not editable in the document?
Non-negotiable to whom? I get standard term contracts all the time that say non-negotiable, but by the end of the day,
we're talking about, respectfully, sir, we're talking about a document that's there to protect the people of Arkansas and the taxpayers of Arkansas.
And again, you heard Representative Gazaway describe the Andrews case, where whether the contract says we waive sovereign immunity or not.
So you agree with Andrews?
No, because the Supreme Court's walked Andrews back a bit since then.
Okay.
So
have they walked that portion back?
I don't want to misspeak. There are aspects of Andrews that have been addressed, but more than anything else, Andrews did not address any case like this one, where it is an intragovernment dispute. And to be more frank, I think this is an important discussion, and that's why I'm here to answer your questions, and I'm trying to.
And I appreciate you being here.
But this is something that has happened once this century, and twice, to my knowledge, twice in the last 100 years. The last time an Amendment 33 action was filed was in 1995 by the University of Central Arkansas.
And if I can, let's get back to the contract. So
the procurement document.
The service agreement.
Okay.
Yeah. The one that once signed supersedes, per the terms of that agreement, supersedes any other agreements. That's what the document says.
I think until or unless, I think the board certainly could vote to nullify that document, and I think the parties could agree to do so and just stand on my engagement agreements, and I think that that's something that could also be done. So retroactivity or future application, those are things that can be addressed between the parties and the allocation of liabilities, et cetera.
Okay. So you agree, I guess, clearly that moving forward, because you've mentioned 7-11 quite a bit. You've mentioned Amendment 33, all of this clearly being litigated. So, I mean, I presume then you agree with Judge James's order when she says that Amendment 33 created the Board of Corrections.
Of course, it did. So I hear, Senator Dismay, I hear what you say, and I heard the answer whether the legislature created the Board of Corrections. I think I understand what you're saying.
No, real quick, let's get back to it, because you answered my question when I said what Judge James said, and you said you agree.
I agree with her order.
Fair. Thank you. That's all I ask.
Senator Hammer.
The one thing I'm trying to get my mind around is when you said, and by the way, I hope your daughter's doing well. I don't ever want to be, I hope she's doing well and your wife's doing well. The one thing I guess I'm trying to get my mind around is if the first thing you had to do was go into research mode, given your history of dealing with multiple government entities, what made you, in your opinion, more qualified that you would be the one that would be hired without interviewing any other attorneys by the board?
I can't speak to the board's deliberative processes. I'm not certain that I understand your question about what made me more qualified or going into research mode. The research mode was on more ancillary issues, such as whether there'd be an ex parte temporary restraining order, or a preliminary injunction which requires notice to the parties, or whether it'd be such a motion at all, or more strategic issues surrounding what types of motions or under which rules we would proceed. And so those are more, what would constitute irreparable harm that was imminent. Those are the types of issues and things that I was looking at. But as far as what would make me more qualified, I can only just recite my experience. I've been hired by numerous bodies of the government to serve as their special counsel. And I think this body is certainly aware of that. And I think that's a question that I would defer to Mr. Watson or my own experience and resume.
Okay, thank you.
And Senator Dismay.
Thank you. And we can just go through some yes or no's. And I do appreciate some of the discussion, though, the fact that you were suing the board, or you're suing a department that then was going to be compelled to then pay you to sue the department. There's some really interesting gymnastics in seeing how that would work. I'm disappointed that Mr. Watson or someone with the board didn't advise that didn't have their own appropriation to even follow through with payment before they solicited your services. But back to the solicitation of services. So Mr. Magnus was very clear that he had charged Mr. Watson with hiring an attorney, not to go out and have conversations about, what do you think about this, or what do you think about that, or hey, there's this adjunct professor over here that's going to be really engaged, want to do things for us because we're right down his alley for free. He said he wanted to go hire an attorney, right? And this happened several months, which follows pretty well with the timeline. So this isn't your conversations, these were his. And so I'm going to go through the timeline and just ask a simple question on each one of these dates, and it's just yes or no. And the question is, did y'all have a conversation about bringing you on as an attorney? Okay? The initial meeting, November 9th, 2023, was there any discussion about hiring you?
No.
Okay. And then we went to the 17th. There was a couple of phone calls in between that. Was there any discussion about hiring you on November 17th?
No.
Okay. And then we go to November 20th, which if I'm reading my notes right, was that the day of the press conference?
No, November 17th is the day of the press conference.
Okay.
November 20th is the date on which Chairman Magnus issued his letter in
Okay. response
to that conference,
Yeah.
and no.
And in that conversation, even though you were helping kind of draft up a response, they had not advised or asked you to. So far to this date, even though well in advance of this, Mr. Watson was charged with trying to find you to hire you, he had never mentioned that the board wanted to bring you on as an attorney.
To my knowledge and my recollection, no, Senator Dismay.
Okay.
I don't think there's any discussion of that. I think that frankly ratcheted up after. I think, to be frank with you, I think the board was hopeful that the governor would be able to help calm the seas with all this.
But
to be clear, this is not a fight with the governor. I think this is just an internal employment issue with Secretary Porfiry. And my recollection was that after November 20,
because I know that your time's valuable, and I just want to get to yes or no.
After November 20 is maybe when I think December. I don't know if it was like December 5, December 8, whatever
but
date that
sometime
I created.
so maybe a few days before the December 8th meeting, Mr. Watson finally disclosed, hey, I've been using you for free so far, but we're probably going to have to hire someone. I've been supposed to hire someone for a while. Would you like to come on as our attorney?
That certainly that's not the conversation. No.
Did he ask you? So you're saying, so on November 5th, he asked you to, would you look at representing us, or can we get a copy of the engagement letter?
I don't think I'd ever spoken to Mr. Watson by November 5th.
December 5th.
December 5th. To be frank with you, and I'm trying to answer your questions yes or no, I very well may have just printed an engagement agreement and said, here, if you guys need this, here it is.
Oh.
I don't know that he actually solicited one from me. I just said, here, it's more of like a discussion, like this is what mine would look like if you have other alterations to it, et cetera.
So Mr. Watson didn't ask you at any point to come on as the attorney. You asked him if maybe these things are getting complicated enough, I should come on as the attorney.
There may have, and again, I'm trying to answer to my recollection. There's a lot happening then. It may have been a conversation. We may have kind of jointly reached that discussion point, but I remember giving him a copy of my engagement agreement. This is what it would look like.
But he may not have solicited it. You just gave it to him. And said, hey.
I would defer to Mr. Watson's memory on that.
Okay.
I truly don't recall if he solicited it or not, but I know that I was thinking that they were. I just didn't know how they could. You've got the Attorney General yelling at you on TV. I didn't know what they were supposed to do with that, and so I thought they needed counsel.
I mean, and the first thing, and unfortunately, and I wish they'd advised you, they don't have an appropriation to even pay you. And then you turned around and sued the entity to pay you, that they're using for the vehicle to pay you, the Department of Corrections. The board, who you only represent, you've made very, very clear today that you do not represent the Department of Corrections, and in fact, you think they're in cahoots with the Attorney General and probably working against you in some ways, or the board.
I wouldn't say cahoots. They're represented by the Attorney General.
Exactly, which then puts us in this weird, realm that we're in. But, you do not represent them. 100%, right?
I do not represent them.
And so the contract that was going back and forth, even though they had charged Mr. Brown and Mr. Watson, by the way, you emailed it to him to ask him to review it too, or here it is. I think he was one of the ones that were CC'd, if I remember the email correctly. But even to your own point, you wouldn't have expected Mr. Brown. I mean, the contract was never between Mr. Brown and the Department of Corrections and you. It was between the board and you, which they didn't have the authority to create.
So Mr. Brown was given a directive, I believe, on January 22 by the board. I could be wrong on the date, January 25, whatever day that meeting was, to do what he was supposed to do in getting the bills paid. And so he reports and is answerable to the board, which is obviously kind of the underlying issue here.
So, and we're going to have these discussions about Amendment 33, and this is really for the board as we move through and have these conversations. I mean, you hired an attorney that you didn't have the authority to hire with money that wasn't yours, and then turn around and sued yourself, which then complicates the whole issue of Amendment 33 and independence and what that's even supposed to look like or mean. But with that, I appreciate it. I think that what I'm going to take from this as we move forward is that you're actually the one that, well, we'll wait and talk to Mr. Watson, but you may have been the one that actually solicited the want to represent the board in these matters, turning around and suing the state of Arkansas Department of Corrections.
I don't know that I would use the word solicitation. I think it was like, it's pretty clear this is getting hot. This is a copy of my engagement agreement. This is what it looks like.
Which is soliciting. I mean, that's what, I
didn't solicit Lee Watson for anything. And Lee Watson can't do anything on his own. I merely provided information. This is what my contract looks like.
Okay.
Not a solicitation.
I'm not an attorney, and there's some nuanced reason you've answered that question that way, but I will find out why. Thank you.
Just to be accurate.
So, and I'd be very interested to see where you're going to get that $200,000 from as time goes along. So, Senator English.
Oh, thank you. So you had talked a little bit about the fact that you represent you work with a lot of different state agencies, UAMS and ADFA and all that.
The disclosure is that my firm represents UAMS and ADFA. I do not represent either of those entities.
So I guess my question is, each of those agencies has a general counsel, and it's my understanding that the Attorney General's office is supposed to represent them. In what capacity would your firm be representing UAMS or ADFA or any of these other state agencies? In what capacity?
On specialized legal issues, for instance, immigration compliance matters, the best immigration attorneys in the state are Misty Borkowski and George Ernst, and they are my partners, and they do a lot of immigration work to help bring talent to Arkansas.
So when you do a contract or your firm does a contract, do you have to go through an RFP process before, and your firm applies for those contracts?
Senator English, and as someone, as your constituent, by the way, just appreciative of someone from North Little Rock here. I want to answer your question, but be clear about it. Yes, absolutely, we respond to RFQs frequently, and that is the method through which we obtain that work, where the Attorney General is supposed to be the default attorney. I'm not suggesting, well, I do believe that it would be helpful to the bar if the legislature clarified 702 and 711. It's been a long time since I've been given a fair look, but to be clear with you, 711 says when a constitutional officer has a disagreement with the Attorney General about the application of a law to it, they're allowed to hire special counsel and resolve the matter by litigation. And so the RFQs aren't where we have a disagreement with the Attorney General about the application of a law. It's to support and assist the Attorney General, given our unique abilities and specialties, so that we can do the work of the state, so we can bring these employees here. And so that's one context. In other contexts, and again, I don't want to name specifically which entities I personally have represented, but I know several of you know at least one of them. And again, I can say that I've worked with each branch of government, and in my experience, I have not received that work through an RFQ process. I didn't go through an RFQ process to represent. I'll just leave it there. I didn't go through an RFQ process in each of the instances in which I've been hired to represent different arms of the government.
So that's typically how we do things, is we issue an RFP, and firms would answer that. So what you're saying is that you are working with a lot of state agencies in almost exactly the same format where you just get chosen. Is that right?
I can't explain to you.
I mean,
why.
I'm thinking we're all sitting in this room here, and we kind of know what the process is. So I guess my question is, does somebody just arbitrarily decide at ADFA that you're the person that they need and they hire you?
I wouldn't say it's arbitrary. I would say it's based on my experience and abilities.
But aren't there a whole lot of other lawyers probably with good experience and background? So, it would seem that's kind of the process I thought we use, is that we it's what we do here in the legislature, to make sure that we are allowing other folks to come to the table and give us their qualifications.
And I in the interest of.
My question is, have you ever done a contract with any other state agency that looks like this? Have gone through this process?
Oh, no, I have never done a contract with a state agency that has gone through procurement, but I have gone through several. I've done a lot of work using a nearly identical copy of my engagement agreement for multiple government branches. And I'll leave it there. I don't want to say more, but if you know what I'm talking about, I can confirm, but I'm not going to volunteer that information.
Okay, I have a hard time understanding how, if you have been working with state agencies before, you would not understand what that process was, and you would automatically think that this process that you all have been going through is appropriate, and that there is no RFP process, or we're going to talk to a lot of different people or anything like that.
In certain circumstances, my understanding is that when the amount or the anticipated amount of the agreement is below a certain threshold involving professional services for constitutional officers, a different set of procurement rules apply. That is my understanding, but I would defer in part to, I would almost want to ask, I'm not sure if Director Garrity is here, but I'd almost want to ask her. I don't know. I don't know what process would be followed in every case, but I can tell you that my process with the board has been consistent with every other instance in which I have been hired by a similarly situated arm of the government.
So we might say the Attorney General's office, or we might say the Secretary of State's office or the Treasurer's office, but not the Department of Finance and Administration.
So
That there's a difference there between those agencies or those constitutional offices and what the process is with the Department of Finance and Administration.
I believe the procurement law makes a delineation between constitutional officers and departments. Constitutional departments, I think, is the term used in the legislation, and non-constitutional departments. So yes, to answer your question, the Department of Finance and Administration hasn't been tested yet, but I actually think it now might be a constitutional department given Amendment 98. But neither here nor there. I don't think anyone anticipates it or construes it as a constitutional department. So a different set of procurement rules would apply for DFNA than it might apply for the Secretary of State, for instance.
But
Or-
having worked with a lot of different state agencies, I would assume that you would understand what the process was there, and you probably think in your firm's mind that this is the process we're going to have to go through in order for our firm or you to be hired by some agency, whether it's a constitutional office or whether it's a state agency.
So yes, in the ordinary course, let's take the immigration work, for example. In the ordinary course, I think there's like some yearly procurement, an RFQ, and a response that is provided. That's standard where it is not involving a constitutional officer or office or department with a disagreement involving the Attorney General. In those cases, the Attorney General signs off and approves our hiring. In this situation, what I want to say, and I don't know if it's answering your question, but what I'd like to identify is that there was an emergency. On December, I believe it was December 11th, the governor gave a directive to Secretary Proferi to open additional prison beds up. And that, coupled with Act 659's effective date of 1/1/24, and the need to get the litigation served, required an emergency action that didn't leave an opportunity for this RFQ process or an RFP process. I cannot tell you who else the board.
Who made that decision that that was an emergency?
I believe the board did on December 14 when they voted to tell me to file suit.
Well, I think we have some real questions. I have some real questions in my mind that the process and how anybody could think that this process was okay when this is not the process we use with everything else. So thank you.
Thank you, Senator.
Thank you, Senator English. And Mr. Mehdizadegan, what cabinet level secretary agencies have you represented?
I don't feel comfortable answering that question.
We're the ones that pay the bills. I'm not asking you any specific litigation. I'm asking you what cabinet level positions have you provided services for?
The executive subcommittee of the ALC.
And?
Others that I'm not comfortable disclosing.
Okay. All right. Senator Petty.
Thank you, Mr. Chair. And I want to I'm just going to make a statement. I understand what you're saying about this is a unique situation, but I'm going to go out on a limb here and say that the vast majority, if not all, of your previous work has gone through this, and it may be as simple as an attachment, but somebody from your firm probably signed the agreement at that juncture for those contracts.
I can affirmatively represent to you that in some of the work that I've done for different branches of government, no one in my firm has signed a document like that in the work that I have done. I am certain, and I'm certain for the UAMS work or the immigration work, those types of things that we have, I can tell you definitively that for the work that I have done, I have not. I've never seen a document like that presented to me for signature before. I didn't receive one from this body when I was hired to be its special counsel, or the ALC, excuse me.
Okay, and we could obviously verify that with staff here if we wanted to. That was just a piggyback. So a couple of things that you have said that kind of bothers me, and I just want to give you opportunity to clarify, and that is going back to the sovereign immunity. In the beginning, early on in your testimony, it was almost as if that was a nonchalant, almost irrelevant tenet of the law, the way I took it, because you were making these minor modifications, and that was not a big deal. And I just wanted you to clarify if that was your intent or if I just misunderstood.
Oh, I don't mean to say sovereign immunity is not a big deal. It is certainly an important issue. I am just not, I don't wear a black robe to work, and the people who do answer those questions. I don't. And so whether we all can sign some contract that says it's waived or it's not waived, the Andrews case says it doesn't truly matter what we say. It's really up to the courts to decide. And so that's why I thought, if applicable, what I haven't heard is any criticism of that revision. I think it's fair. I think it maintains the status quo, and it doesn't really change the nature of the provision. If sovereign immunity applies, then it applies. But if it doesn't, then it wouldn't. And I think that's a question that the Supreme Court, a different branch of government, makes. And again, coming from a position of a constitutionalist, I defer to that branch to make those decisions. And so I don't take it lightly, and I appreciate the opportunity to answer the question. I do think it's important. Okay. I think it has substantial, critical applications in most facets of the law. In this one particular one, I'm uncomfortable making a statement about it because it's not my place. That duty is of the Supreme Courts to decide that question, and obviously we have active litigation involving it.
But at least in some vein, you question whether that would be applicable in this situation, and that's why it was even addressed.
So I think, to unpack it a little bit, what we have are two parties to the contract. Myself, or my firm rather, and the Board of Corrections. I would like to get paid for the work I've done, and they would like to pay me for the work I've done. And so I don't anticipate a necessary fight with the client where they want to pay and I would like to be paid. And so I don't anticipate sovereign immunity really being an issue here. I think the consistent position of the board is that they hired me to do work. I did a lot of it, as well as my team, and that they would like me to be paid for that work. And so I don't anticipate a fight with the Board of Corrections about paying me. They have voiced a desire to do so.
Okay, and so the sovereign immunity, and Mr. Chair, if you don't mind, I've got one more question here, or line of question, but the sovereign immunity applicability here is in terms of payment of your fees and not some litigation related to liability or anything else that we're opening up a big can of worms.
I think as a matter of contract law, it would probably be construed only to apply to a dispute between me and the Board of Corrections.
Okay, and so you articulated you don't wear a robe, and I respect that. And I'm not an attorney either, but I do think that where my next question or line of questions here does relate to where your expertise is, and it's in contract. And the other thing that you said that kind of bothered me in reading these, there was a disagreement as to whether this was a services agreement or the engagement letter or what controlled. The way I understood your testimony, your engagement letter controlled your services. And that was the controlling document that you agreed with the board on for your services. But yet this document, this exhibit, there are two, one that was not signed and then one that you admitted that you had helped or added some edits on. Throughout the document, it says contract. It says contract. It says contract. As a matter of fact, it even on one of the pages, you added to it at the top your engagement letter. So to me, and I'm not an attorney, I would think that this is going to become the controlling document with the supplement of your original engagement letter. And again, I don't want to chase a rabbit hole, but the fact that you said that this really wasn't a contract, but yet throughout the document it says it's a contract, and there were the staff, the procurement staff, we are pretty confident, and the report we heard from earlier says that they prepared it, but there was some substantial changes. For example, emergency. I heard you in your testimony talk about emergency. That was added after you added to it.
If I could speak to that,
But
I believe the document that I received, I don't think anything in that box was checked. It was blank.
Actually, it says request for qualifications.
I believe if I saw that today, just as I was sitting here, I believe in the version that was sent to me, that part was blank. And it was there's a drop down menu. I believe, it's my recollection. I could be wrong. I can verify that as soon as get out of here. But there was a drop down menu. And again, if it did say RFQ, that's not accurate. That was not accurate. There was no RFQ. This was an emergency.
I got you. And RFQ, RFQ.
It has a contract number. It talks about a bid. It was all over the place with terms that I had not seen, nor had we agreed to. But I had been working for the board for months at this point, operating under my engagement agreement.
Did you strike the bid and the RFQ and the items that you had like you did sovereign immunity?
I didn't strike sovereign immunity. I also
edited the language in the non-negotiable section.
If applicable. So I don't think it really changed the substance either way. I did, if you look at the documents that were submitted, I did email Ms. Gray multiple times that morning where I was supposed to be at the negotiating table for a labor agreement on behalf of an employer. Emailed her numerous times, 2 or 3 times, saying, what is this? Where is that? What bid? What RFQ? And the answers I got back were odd, but satisfactory for me in that there wasn't anything that was made up and it was just a placeholder. I think that's weird, but this is obviously an unusual process or proceeding. And, I expect these are issues that don't come up often because there's not much constitutional litigation of this sort.
Yeah. And again, just to clarify your previous testimony, you're saying this document that you signed is or is not a contract?
I think what we have heard is a repudiation by the board of it, and I stand by the board in that respect.
All right, so yes or no? I may have missed that. I may have stepped out. Repudiation, saying it is not a contract? They're just trying to get it before. What is it when it says contract throughout, and it gives priority of weight in legal terms of the documents to consider in disputes? But if that's all irrelevant, then we didn't need your signature anyway, did we?
Well, apparently not for something to get uploaded into the portal, because what was uploaded into the portal I had not seen, nor had I signed. So apparently you didn't need my signature on it. Or if you did, no one asked me for it at that time. But to the extent that it says services contract, what I was trying to say is that the board came before the ALC under the pretense that it was a ratification request. And there was a ratification letter submitted to the ALC. That is what brought them here. Right before, I believe, the ALC met, they were told to sign this document. And I think you can defer to Chairman Magnus or Mr. Watson or Dr. Byers, I think their understanding was that this is part of the ratification process. Mine was of the same variety. What I attempted to do is make this document as consistent with the terms of my engagement agreement and with the practice in which had been engaged for the months prior to receiving this document.
So clear. Last question, I promise, Chair. So clearly you read it. There were there were some things that you've referred to that gave you cause for pause. Clearly you read it. You're an attorney. You're paid to read documents, and it says throughout it's a contract. But and you signed it ultimately. So you opined to everything that was written. Maybe you didn't agree with it, but you got comfortable with it. I just have a hard time understanding what the goal was by doing this if it's not a contract. It says contract throughout.
It does. The goal, as I understand the Department of Corrections from Chad Brown's statements and Dr. Byers' analysis, was to pay my legal bills. That was the goal. I understand that it says services contract, and I accept that. I don't want to disagree with you. I accept that it is an agreement. It is a contract. It is mutually signed by both parties. It identifies the substance and scope of the engagement. My effort in the revisions that I supplied while it was an offer was to make this document consistent with the engagement to which the board entered into with me, without changing anything in terms of how our legal arguments were proceeding at that time. And one other point that I'd like to make, and I heard Representative Springer ask this question earlier about whether the order was on appeal at the time that whether Judge James's decision in the Amendment 33 litigation was appealed. There's an annoying lawyer answer to that question, yes and no. Yes, a notice of appeal had been filed, but that does not divest the Circuit Court of Jurisdiction. The act that divests the Court of Jurisdiction over most issues anyway is the lodging of the record, and that had not occurred. The state had not lodged, the Attorney General had not lodged the record in that case until after I had submitted this. And so at that point, when I was signed this document, all that stood was Judge James's order, and that's really still the case. So I did want to clear that up for you. But to answer your question, this is obviously, again, an unusual situation. My team spent a substantial amount of time working to advance the interests of the board, which I want to make clear here. We all took oaths to support the Constitution, and they're doing it at great personal expense as unpaid volunteers over this board. And whether we disagree or agree with the policy behind it, that deserves respect. They've stuck their necks out to do something that's important that my two kids will benefit from. I benefit from a state that supports its Constitution and enforces it. And I think there's value in that should be respected, and it should at least be acknowledged that these folks did not have to do this. The easiest thing to do would have been to do what they were told. But that's not what the Constitution says. And I think that deserves respect, just like the labor that my staff poured into defending the Constitution.
So, excuse me,
paid.
is there an answer to the question there somewhere without all the editorializing?
I believe, I hope I answered your question.
He did. Thank you, Mr.
Okay,
Chair.
thank you, Senator, and Senator Hammer. Okay. And how many hours have you billed the Board of Corrections thus far?
I am not certain off the top of my head. I believe what has been billed is approximately 337 hours as of my last look, but we're in the middle of actually an update in our billing system, so I couldn't, as of I think March, that number I believe is accurate.
Okay. And let's go to Representative Beatty.
And when I say billed, I don't mean to say me personally, I mean my firm.
Okay.
Thank you, Mr. Chairman. Abtin, I'm here on this side. A quick question, my question's in reference to your March 12th letter to the Board of Corrections, I think an email, where you state, I guess in the closing paragraph, you look forward to clearing I quote, I look forward to clearing my name and answering any legitimate questions that the ALC or any of you may have. Do you feel that the questions asked by this committee are legitimate questions?
100%. I didn't mean to misread into that. Questions that I can answer is what I meant to say. A question that would not be unethical for me to answer.
All right. And then a quick review. You said you've represented other agencies in the state in the past, and a quick review of Transparency site does show several agencies that your firm's represented and billed for legal services. Have you ever signed an engagement letter with a board that does not have a budget or appropriations to pay your legal fees?
I
until now?
want to answer your question. I don't know that I accept. I don't want to disagree with you, Representative.
Oh, you
I'm not
can.
trying
A lot
to
of them do.
there is a statute, for instance, that allocates the board the power to hire a compliance administrator who happens to be an attorney. And there is an appropriation for the board to do that. And so the board does have an appropriation, as I understand it. I could be wrong in terms of kind of ordinary parlance, but there is a statute that authorizes the board to hire, and and it specifically says the compliance administrator reports to the board, and the appropriation has a position for the board to hire that person. So I do believe the board has an appropriation. Or the inherent, to be more clear with you, if the board is responsible for the entirety of the Department of Corrections, then it oversees and sits in judgment of the Department of Corrections and has superintending control of the department's appropriation.
Well, again, your letter, you kind of foreshadowed exactly what we're looking at here, where you state that you're not going to be surprised that the same legislature may be looking for reasons to avoid paying a legal bill.
It doesn't surprise me. Again, this is an appropriate illustration of the balance of powers the people of Arkansas chose. Your job, and you're doing it well. I do not begrudge any of you, and I respect all of you for the public service that you do and the positions that you're taking. I have no grudge with any of you, and I appreciate the questions, and you're doing your job, which is to be this branch of the government. I challenge the law that you passed. It would not surprise me that you might be frustrated about that. It is not my intent to frustrate. It is my intent to do my job as best I can with the best team that I have behind me, and to support the Constitution. I read my oath as an attorney frequently. I think more attorneys should, and some of the provisions of it. Do not turn your back on the defenseless or the oppressed. I'm not suggesting the board's oppressed, but they're defenseless when the Attorney General is chastising him at a press conference with the legislature, with the governor. Not to turn our backs on causes that might bring us into positions like this, where I'm hitting articles in the Democrat Gazette, having this intimation of some type of untoward conduct, when all I did as a lawyer was edited a draft of an agreement and sent it back. But that's your job to do this, and I respect it. And I appreciate that you're doing it, and y'all are, again, doing it well. I don't want to misread, and I appreciate the question you asked. I don't want anyone to misread my email to the board. There are legitimate questions that I can answer, and there's some that I simply can't. And so that's all I meant by that. And again, it wouldn't surprise me, given all of the media surrounding this, that y'all might not want to pay my legal bills. I would ask, and I don't think I'll change any minds here, I would ask that y'all give that fair consideration. There was a lot of time was spent on it, and I don't want to say look at the scoreboard, but we've won, and we've won consistently. And I say all that in suggesting this: there is an easy path to de-escalate. All that we should do, a meeting with a representative from the governor's office, from the board, and from the Attorney General's office, and myself, I think would get all of this wrapped up. And I have been begging the Attorney General to meet me at the table to do that. I hope that they take that invitation at some point, because we can save the taxpayers dollars, and my staff can get paid for the time they spent doing their jobs.
Well,
Okay, Mr. Beatty, did he get your question answered?
I did. I want to appreciate you for clarifying your comments in your letter and for your testimony today. Thank you.
Thank you, Mr. Beatty. Mr. Gasaway.
Thank you, Mr. Chairman. Mr. Abtin, I do want to take a little issue with something that you said. I mean, you sit there and act as if the "if applicable" is just a simple edit that was made in the regular course of submitting edits to a contract. This is not a normal situation, as you've acknowledged. You said once in a century. It's been a matter of public concern and controversy. This is a pretty big deal. Wouldn't you agree?
Yes.
And it's not just as simple as making, again, edits in the normal course of business. what you did was you made an edit on a portion of the contract that specifically says non-negotiable in red. This provision is non-negotiable. Now, I suppose if you're just making edits to the document, you could make edits to any portion of this. It's either all editable or not editable. And this says non-negotiable. In other words, this is not up for negotiation. You didn't amend lots of other sections of this, but you did amend that one. You did edit that one. And you edited it by adding if applicable. Now, why would you edit that section to the exclusion of the others? Well, it just so happens that the issue regarding sovereign immunity affects whether or not you may be able to get paid under this contract. And that's why you edited that portion of the contract, isn't it?
No, if I may, Representative Gazaway, excuse me. If I may, any time where there was a reference to a statute that I didn't have time to research what it meant or to understand whether or not it applied to constitutional officers or constitutional departments that have special procurement rules, I wrote if applicable. And so I did that on page...
Okay, let me stop you just for a second. So, if we were to go through this contract, we could say where you get to the provision about governing law, choice of law and venue, if applicable. There may be some legal theory out there that would say some other law should apply. There may be some legal theory out there that would say maybe Pulaski County isn't the best venue for this because these actions were taken in another county. You could have added, if applicable, to that provision. The intergovernmental cooperative use about the state procurement unit may participate in this contract and participating addendum signed by the contractor and approved by the chief procurement officer. You could have added, if applicable, to that. Disclosure required by executive order. You could have added, if applicable, to that. You literally could have added, if applicable, to nearly every provision of this contract if you wanted to take issue with it under some legal theory. But you really only added it to the sovereign immunity section.
Respectfully, no, I didn't. Representative Gazaway, as I was saying, if there was a statutory reference, but I didn't understand what it meant, I did that. So if you go to section 15, amendments, it quotes statute, Art Code and 19-11-265. I wrote if applicable. And I do want to just explain why I use the typewriter.
But hang on, let me stop you first.
Sure.
So section 15 deals with an amendment that increases compensation. So once again, you added, if applicable, to a section that deals with the way that you would be compensated under this contract. It appears that the only provisions in this contract that were worth amending or that were worth adding, if applicable, to were the ones that concerned whether or not you would get paid.
No, respectfully again, so I'd point you to 12A on the same page. 12B, excuse me. I have no problem being ethical and complying with whatever ethics provisions apply. I did not have an opportunity.
Well, the way I read that, subject to the relevant ethical provisions of whatever, you say if applicable. In other words, that's an out. I'm subject to those ethical requirements if they apply. I mean, that's not because I want to be ethical. That's so I can have a way out of being ethical.
No, it's not. That's not my function. My purpose here is I didn't want this signature to represent an admission that the Attorney General would then wave around in court to say, aha, Abtin agrees that this section applies and this statute comes from this section of the procurement law, and therefore this procurement law applies and 711 doesn't.
And so
my only effort was to not give up any ground on the status quo.
So I would go back. Yes, no, absolutely. The point is that you edited this contract in every portion that was beneficial to you. It would be beneficial to you so the Attorney General couldn't point out about ethical obligations, then that's if applicable. If it's about whether or not you can get paid under whether or not the legal theory of sovereign immunity applies, then it's if applicable. If it's the portion about payment for professional services and compensation, it's if applicable. At every turn in this contract where it was beneficial to you personally, whether that was from an ethical consideration or whether that was from a financial consideration, you edited the contract to say if applicable. All the rest of the provisions don't matter. All the rest of the provisions fine. Don't touch those. But if it's ethical or financial, it's if applicable. It's clear.
No. And may I respond? No, respectfully, no, that's not the case. And let me just make this clear. The statute, 711, deals with the ability to hire counsel and for the counsel to be paid. So those two issues are married together. And so the board's interests and mine in this respect are aligned because the Attorney General has moved to dismiss the complaint, arguing that it is a nullity because they argued that 711 doesn't apply. And so if 711 doesn't apply, it means that the lawsuit goes away and the board loses. And so whether or not my payment is a part of that calculation, it also goes to the heart of the ability of the board to proceed with its litigation and to vindicate the Constitution that we have all sworn to uphold. And so those two issues are married, and I understand it's a nuanced legal issue that you and I might be some of the few capable of understanding it and unpacking it. But those two issues are married. And so no, it wasn't anything to do with, well, I don't want to agree with the ethics rules. I don't want to agree with this. I didn't want to make an admission on a short notice basis because I didn't have the opportunity to do the research because I was told to sign it that day. I didn't want there to be any argument that 711 doesn't apply because 711 goes to the heart of the board's ability to vindicate its rights under the Constitution and to pay me. And I absolutely accept that. And let me be very clear, Representative Gazaway. I want my firm to be paid, and we deserve to be paid. And we've done good work to get paid. But if the payment issue if I cannot get paid because of some procurement law, then there is an inherent concern around whether the board had the ability to hire me. Now, Judge James, in her order, I think has clarified that concern. But I will also tell you that I've consulted with ethicists at the highest level of our state and asked their opinions and spent my own personal money to get an ethics opinion about what I ought to do moving forward and whether, how this kind of unique dispute, whether the Attorney General and the governor should have some control or say over whether the board gets to hire a lawyer. And the ethicists with whom I consulted said, no, proper constitutional litigation requires competent counsel on both sides, and the defendant doesn't get to choose the plaintiff's attorney. And so I've attempted to operate in the highest ideals of our profession, and I hope whether you disagree on either side of it, I hope as a member of the profession you're proud of the work we've done.
I can see your theory. Once again, I just can't help but notice that in every portion that it would be beneficial to you personally, you added, if applicable, and all the rest of the contract was fine. And I don't think that is, again, I accept your explanation for what it is, and it may be very well be the case, but I just seems more than just mere coincidence to me.
I can appreciate your position. I appreciate this ability to engage in the dialogue. Thank you, Representative Gazaway.
Senator Hammer, you're recognized.
Thank you. Just on the timeline of things, you handed Mr. Watson an engagement letter, if I'm using the terminology right, because you thought things were getting hot. Is that correct?
That is my recollection, yes.
Okay. And then after that, entered into the actual contract. Is that correct?
I'm sorry. So I know that there'll be a record made of this. I want to be accurate. I provided a copy of my engagement agreement, and the board on December 8th voted to hire me, and they signed it. So yes, that became the contract. And then again, it was supplemented on December 22 after the Attorney General sued its own client.
And then it was, because I'm looking at it, it says this letter serves as a supplement to my engagement agreement. So that is after the original contract. Is that correct?
Correct.
The letter's not dated. Do you know when that supplement was actually submitted?
The board voted on it and approved it and signed it, I believe, on December 22.
On December 22. Okay. All right. I'll go back in the queue in a minute, Mr. Chair. Thank you.
Thanks, Senator Hammer. Senator Dismang, you're recognized.
All right, just real quick, because there is one difference between every other agency or department or whoever that you've represented. They had the ability through appropriation to pursue you through professional services appropriation or whatever it may be. They are different. And I just want to be very, very clear. Even if there was a quality, which there's not, but even if they did have the authority to hire a compliance officer or whatever, they are beholden to what that appropriation requires to be able to expend funds through that. And there was a comment made, and I just want to make sure that we're all inside the same room here, and they are not in control of their appropriation. That we set appropriations, we control the appropriations. These are the throttles that we put in place as the legislative branch. So
I do not want to get into a disagreement with you, and I understand that this body should push back on what I'm about to say. But there is a case, the Cheffin case, Chaffin, Chaffin, and it deals with it, again, it's from the Secretary of State's brief in a lawsuit Matt Campbell filed against them. It's quoting, and I think this is insightful. The Supreme Court said in Chaffin, the advice offered by the legislature to a constitutional agency is tantamount to a legislative order on how to execute a contract. The Arkansas Constitution contains explicit separation of powers provisions which declare that one branch cannot exercise any power belonging to another branch. An unconstitutional encroachment may not always take the form of outright invasion. A subtle coercion exercised by a powerful branch of government can effectively tie the hands of a coordinate branch. The executive authority should be free not only from blatant usurpation of its powers, but from paralyzing interference as well. The legislature cannot hold the executive branch hostage to its will, while it can and should hold hearings and investigate at length the performance of state agencies. It cannot intrude on the prerogatives of the executive branch of government. And that's Chaffin versus Game and Fish.
Still, every one of those agencies have to have the authority to spend. That can't be taken away. I think your argument is since we didn't give the authority to spend, then we've hung them out to dry, so then they can't defend themselves, and so then they get whatever they want to get. I mean, appropriations are put in place for a reason. It was not too long ago we had a constitutional officer that was being sued by an employee, and we were the ones that allowed that constitutional office to have a re-up in the appropriation because the bill kept growing and growing and growing. We could have made a determination not to as a committee, and then those bills would not have been paid. But again, I would just tell you the difference between all these other entities that you've been talking about or maybe represent, they had appropriation authority. These folks did not. And in fact, I mean, just to even play it out a little bit farther, it seems if you can do and make it make sense in your mind that you are suing the entity that's going to pay you, then good for you, because I can't. Which then brings you back to the whole deal of none of this makes sense, and why we're here doesn't make sense. And so that's for the members. Just for the members, there is no appropriation for the department or the Board of Corrections to pay an attorney out of. And so what I would say would be, there's been mention, we talk about, the pieces or what's got to be contained in a contract. There's got to be an offer, an acceptance, awareness, consideration, which they had no authority to provide to you because they have no appropriation to even provide you consideration, capacity, and legality. There's at least two of those that lacked from this being an enforceable contract, in my opinion. And so I don't know if and I apologize they didn't advise you that they didn't have an appropriation, but they don't have an appropriation.
So if I may respond to this, it's two things. Number one, y'all could fix this and make this drama go away. Y'all have the power to do that, but not this committee itself, but as a legislature, this branch of government's pretty powerful. You could help us learn from this, and it probably won't ever happen again. So y'all can fix this problem for us if you are interested in doing it. But number two, and more to the point, your point's well taken about the constitutional officer issue. What I want to say is that if this body, for instance, passed a law that, for whatever, intentionally was unconstitutional, and didn't want that law to be challenged by the only person who could have standing to challenge it, then you'd also say, okay, we're going to pass this unconstitutional law and not give them an appropriation or not give them a specific appropriation for outside counsel.
But I would
and
argue it's
therefore
not
are-
unconstitutional, so
and
I'm
they're-
not doing any of those things.
I get that, but
So,
but
but if I would also, and one of the things you said earlier, you were agreeing with an attorney general's opinion earlier. I wish you would agree with some of the attorney general's opinions that's been put out so far, because I would argue most of these members here, just so you're aware, did not, seek out this fight, did not seek out to be a part of this argument. There were certain letters written by board members, accusing the legislative branch of doing things that were just, quite honestly, not true. But most of us did not have a desire to be a part of this until we started finding out more and more and more. And I think, there are clear FOIA violations that have occurred. I don't think that's disputable. I think when you listen to the board members, they acknowledge that they occurred. That's a breaking of the law.
can I speak to that?
I'm not,
As
be
it-
careful for what you say. I would advise, because you have your own track of FOIA laws or FOIA issues that you're dealing with. There was testimony on some earlier that clearly violated the law.
And what I will say is that those violations can be addressed through civil litigation or through criminal prosecution.
Correct.
In a different branch of government. However, from the testimony that I heard, you heard Dr. Byers and Chairman Magnus. These are nice people. They are
No
also
one said they're not nice
they can get intimidated, and I think they misspoke a number of times. And I think I heard from someone here today. We asked if we sent the legislature a FOIA request. We can, as far as I'm aware, I can't send you all FOIA requests. And so my point is that the FOIA is confusing, but because of that, the FOIA also allows bodies to retroactively or prospectively cure a violation. This is not, they're not held to a standard of perfection. They're volunteers.
Oh, no, I'm fully aware.
When an issue is addressed, so what the Supreme Court says, when the remedy the FOIA litigant seeks, in this case the Attorney General, when that remedy is invalidation of an official action, you have to give them notice of the issue and give them an opportunity to cure. And the AG letter says cure it by December 15. They did that. They met on December 14 and in the air talked extensively about all of their discussions and everything else. All records have been certainly turned over.
That is absolutely not true. Unless records were, as you pointed out, deleted so that they couldn't be FOIA'd, they have not all been turned over.
Senator Smith,
We've acknowledged amongst members and you and everyone else that there's been written communication that has not been supplied to this committee and was not supplied when requested.
if it wasn't supplied, it doesn't exist.
Well,
I can't
because it was deleted.
make
Okay.
something for you, Senator. But no violation of the FOIA occurred as it relates to documents. If a request, and I have
I
been
understand the
consulting with
nuance.
another law professor, Robert Steinbuck, extensively.
Are we having to pay Robert too?
No, he's doing it for free, although his
He's
hourly
doing it for
rate's
free, too?
$1,000 an hour, but he's doing this as a public service. And in speaking with Professor Steinbuck, I've consulted with him extensively about this. He literally wrote the book on it, and the board has cured both on December 14 and on December 22. And so as far as FOIA violations, without conceding any that existed, I wasn't in the executive session, so I couldn't tell you. I don't know. But
None of us
there's-
were, and
but
they
there's-
don't keep records.
But
so.
there's subsequent discussions on the record, cure all violations
A
of
3-minute conversation about hiring an attorney is not a conversation on the record.
Senator Dismaying, I think you're aware that was December 8th, the date on which you're referencing. On December 14, the board had a much lengthier conversation about the decision to hire outside counsel. And then again, on December 22, the board had an extensive conversation about
To
it.
try to cure. I agree.
And I think that's all we can expect. If the Attorney General says we did something wrong without conceding it,
If you're
They-
going to
they-
call yourself a constitutional officer, which I would question, I don't think that's anything that's stated in the Constitution. The board was created by the Legislature Act, or Amendment 33 simply states that we cannot take away from the authority provided to the board, but then there's some other provisions that nuance outside of that. I don't think anyone, you have a judge that has said they're constitutional officers. I believe that will not carry itself out. And I don't even believe you're challenging that, to be honest, the Attorney General's assertion that they're not. But that's okay. That's a whole different deal, and we're not going to argue the court cases.
the legislature passed a statute, 25-1106, that defines this board as a constitutional board. It's not just Judge James. It's also this branch of government that construes them as special. All throughout the Transformation Act, it deals with unique attributes of Amendment 33 bodies like the board. All throughout the board's legislation, it says subject to Amendment 33. In this way, you can't look at the Board of Corrections without also looking at Amendment 33. If
I
their
didn't
office-
say you could.
If their office is created by the Constitution, the law, the Supreme Court.
They're not created by the Constitution.
The office of the Board of Corrections.
No, sir.
Literally
Thank you. No.
the second word of, the third word of Amendment 33, Section 1 is office.
So Senator Dismang, did you get your question answered? Generally, thank you. And Mr. Mehdizadegan, we have no more questions from the committee for you. I'm sorry, go ahead, Senator Hammer.
Thank you. Have you provided services for the Department of Correction prior to this contract?
No, sir.
Okay, and on the contract, you reviewed it and signed it yourself, or did staff sign it? The contract that you entered in with the department, you reviewed it, and you're aware what the content of the contract is that you signed with them, correct?
I'm aware of the content of the December 8, December 22 engagement agreements and the procurement document that was signed March 6, yes.
Okay, and if I'm not looking at the wrong document, there's a statement that says this is provided for informational purposes only and is required under Arkansas procurement law and is not performance obligation of the department as an unconditional promise to pay from the source identified, which is the general revenue. You're aware that that statement was in the contract?
Yes, if it's in the contract, yes.
Okay, so there was the possibility then that you knew that you might not get paid based on that statement that's in the contract?
No, not. This document was trying to change the game on us by the defendant. The defendant told us to sign this if you want to get paid. I considered it an unusual process and an unnecessary one, or one that could have honestly been dealt with by a ratification letter, which is what we were told in the first place. So I have concerns with the premise of this document or its propriety. I understand that there's always some potential that a bill goes unpaid. And I hope that that is not the case here, because a lot of people who worked really hard will suffer unduly for it.
And then one last question. You invoked Dr. Steinbuck's name a while ago. Did you just make the statement that what he provided to you, as far as it relates to the services he provided to you, is at no cost? He's not billing your firm, nor is he collecting anything?
He's not billed or collected anything. Professor Steinbuck gave generously of his time and signed an affidavit, or declaration technically, that included his review of the documents, the board minutes, etc., and quoted from his treatise on the topic. He ordinarily charges $1,000 an hour. I did not have approval or authority from anyone, the board or otherwise, to hire or pay Professor Steinbuck's fee. And he did not, I want to be very clear, Professor Steinbuck did not ask me for payment or did not suggest an engagement agreement or anything of the nature. As a law professor expert in the FOIA, I conversed with him in that academic context, and he supplied his time free of charge, free to the state as a service, because he is, again, a knowledgeable subject matter expert in the FOIA.
And that was done on his own personal time and not on time as the University of Arkansas. Did he render that opinion as a private attorney, or did he render that as a professor of the U of A?
I believe most of our conversations with Professor Steinbuck were on the weekends. I don't know what capacity he was in. I'm not going to answer for him. I don't know. My view is that he was providing the affidavit as an expert in the FOIA,
of which he would charge $1,000 an hour for any FOI content. Was that what you said? $1,000 an hour?
No, I just think his hourly rate. I think I've had a conversation with him at some point about. At the time, I think there was some negative commentary about my hourly rate of $285 an hour, which is discounted for this body, or for the board rather. And I said, Professor, what's your hourly rate? And he's like, it's $1,000 an hour. I'm worth every penny, and you're worth every penny. But
I don't get paid $1,000 an hour, but thank you for the compliment. I just wanted to clarify your testimony was with regards to if it was work for FOIA advice. $1,000 an hour is a lot for an attorney to bill for advice on it. Am I misstating or misquoting?
I think I'm conflating the two issues, and I probably misspoke and should have just not said anything.
Okay.
Professor Steinbuck did not ask for or receive or charge anything to me or my firm or to the board or anyone in connection with his public service and pro bono work for me on behalf as a FOIA expert.
Thank you for that clarification.
Thank you for being here today. You're excused, and with the understanding that you're subject to being recalled. And the committee calls Mr. Lee Watson, please.
General Barry, may I ask a clarifying question? I'm very happy to be recalled. I have a meeting to get to at 3:30. May I, if I'm not here and someone asks me a question?
We'll be back on the 11th, so
Okay.
There's potential you may have some more questions on the 11th.
Thank you.
Mm-hmm. Very short, please. We'll stand in recess for 3 minutes. To order, and I see Mr. Lee Watson's there. If you please stand and raise your right hand. Do you solemnly swear the testimony you're about to give shall be the whole truth, will be the truth, the whole truth, and nothing but the truth, so help you God? All right, please take your seat. And if you would, state your name and position for the record.
My name is Lee Watson, and I'm a member of the Board of Corrections.
Thank you for being here, Mr. Watson. So, did Mr. Mehdizadegan provide you with any preparation for today's questions?
No.
Okay, thank you. So what is your prior relationship with Mr. Mehdizadegan?
Well, back sometime in the middle of last year, when through a series of, do you mind if I give you a little background of how that came to pass?
Briefly.
Okay. Through a series of executive sessions where the board discussed Joe Profiri's performance, in particular, in relation to, we went a period where we were used to the secretary requesting board meetings. By law or by, I forget what it's in statute, we have to have a board meeting every 4 months. But we had a period where we didn't have any. We were used to that being precipitated by the secretary. And this was middle of last year. And also, we were asking for information from Joe Profiri, and we weren't getting information that we felt like we were used to getting and should be getting, especially with the emphasis on the Protect Arkansas Act, building a new prison. And through the course of that, when I became aware of what eventually became Act 185, not part of the Protect Act, but Act 185, which changed the wording to say that he serves at our pleasure to the governor's pleasure, Benny and I talked after a board meeting. And it's my understanding for there to be a meeting, there has to be 3 or more. So not 2. And as far as FOI purposes. And I said, this may cause an issue. This person for 82 years, whoever's in this position, whether the title was secretary or director, reported to the board. And Profiri had been indicating, he'd referred to me personally when we'd talk, well, I got to do what the boss says. He's talking about the governor. And as time went by, and I was only aware of Act 185. By the middle of last year, I really hadn't seen the 2 issues with in the Protect Arkansas Act that had to do with the directors, serving at the governor's pleasure instead of ours. And I said, Benny, I don't know if this is going to cause a problem, but it may, and unfortunately it did. We wished it hadn't. We tried to communicate with Secretary Profiri. But as it became a bigger problem, Chairman Magnus didn't authorize me or give me a special label of litigation liaison. That didn't come till after the litigation was filed in December. He said, you're an attorney, would you look to see basically if there are any attorneys out there? And sometime last summer, early fall. And so I started asking around and doing what I've done before and I'm in-house counsel for a company. I've worked for several in Fort Smith. And by asking other attorneys I know, and the Fort Smith bar and the Little Rock bar, there's a little crossover, but I asked attorneys in Fort Smith, hey, these are kind of issues. It's an employment law issue. Who might be out there? And this might be public. And a lot of attorneys, I'm hats off to Mr. Mehdizadegan. Most attorneys would not want to be involved in this sort of litigation and situation. So as I started basically asking around, talking with fellow attorneys, like I've done before, and I've hired attorneys all over the country for the company that I work for, I ask other attorneys' opinions. Sometimes I call them, and even though I'm basically under the guise of I'm looking for somebody that can handle this kind of action, and many of those have been employment law actions, I learned of Abtin Mehdizadegan. I'd been told of others, but for different reasons, I either researched them online and I kind of discounted them. And finally roll forward to November. And to be honest with you, I'd forgotten until Abtin said it today. But around November 9th, somewhere in there, he and I talked on the phone. I called him. And I'd looked him up on the internet. I'd seen what he'd been involved in, understood he was an employment law professor. And at its heart, this started as an employment law matter. We had a secretary that had always reported to the board and been answerable to the board, and now wasn't. Amendment 33 and the statutes tell the board, we have to manage the affairs of the Board of Corrections. Well, how do you do that when the president of the organization is saying, I don't have to talk with you. I don't have to work with you. So we're like, what do we do here? We continue to see performance issues. And we talked about this in executive session about how to address this. Do we discipline him? Do we suspend him? And so when I called Mr. Mehdizadegan, I explained the background. And I was impressed with him very quickly because he grasped the issues. He understood at the heart of this, it was an employment law matter. Because as a board, if you're the board of a corporation and the president of the corporation is thumbing their nose at you saying, I'm going to do what I want to with the corporation, you become a toothless tiger. You can't effectively manage that organization. And I remember in one of these conversations about him in that situation, one of the other board members said, we're quickly becoming the board of nothing because we had a secretary that at that point wasn't responsive to us. So I talked with Mr. Mehdizadegan. I have a son who lives in Conway, and we met for a bite of pizza and to talk. And I was very impressed with him. We continued to have conversations, and that was Sunday before November 17th. And then the press conference happened on November 17th, and I was shocked. I mean, like, here we have the governor flanked by, well, not just flanked by, but with the secretary that reports to us and the attorney general stand there and repeatedly say that we were failures in our job of managing the Department of Corrections. So I'm thinking, as an attorney, I've never seen an attorney before publicly basically demean their own client. And the attorney general at that point was actively representing us in litigation. So it's like, so anyway, I continued to talk to Mr. Mehdizadegan. Fast forward to December, or shortly after that, first Mr. Magnus sent the letter to the governor, made overtures to try to resolve this, to try to explain the situation so we could get past this without any of this happening. None of us wanted this to happen. I mean, it's not been good for anybody, not us, not the efficiency of government, not anything. But we were faced with this situation with 82 years, and to parse words a little bit, Senator Dismaying, the board existed before Act 33, but Act 33 in part is what made us constitutional officers in the statutes. But, whatever that is, and that's what we're trying to sort out. And so in talking with Mr. Mehdizadegan, frankly, I don't think he realized it. I was basically interviewing him, and he spent, frankly, more time with me than I expected that he would discussing these issues. So the governor didn't respond to Chairman Magnus's letter. Things moved forward. And we didn't want to get into a fight, but we're at the point, I think, where we either had to do this or we all just needed to resign and walk away because we were no longer effectively managing the department. And so we chose to fight. We chose to, in talking with Mr. Mehdizadegan and this conflict between the new Act 185 and Amendment 33 and the 82-year history, it's like, well, and he felt like, yeah, you're in the right here. He formed an opinion. I did too, as an attorney. And then, and I'm terrible with dates. We got to the point where we had to take action, and it was an emergency matter. And it became an emergency when the governor publicly said, I don't care what the board has voted. I don't care what they've done. Even though in their judgment, they've been trying to manage these Department of Corrections facilities and comply with national standards, keep inmates from getting hurt. I've only been on the board 4 years, but there's a severe shortage of guards at our prisons. So, we're between a rock and a hard place. If we start just, putting beds in the halls or places they don't belong and we don't have adequate supervision, the state's going to suffer more liability. We're going to have lawsuits. We're going to have bad things happen, and we know that. All the experience of the board members tells me that, and common sense does too. So then the governor comes out and says, well, I'm directing the secretary to add those beds regardless of what the board has determined in its meetings. So at that point, what do we do? And so when we had our executive session before hiring Mr. Mehdizadegan, I said, this would normally be an employment law matter. We have an employee here that won't respond to us, that won't follow our directions, which has been the status quo for 82 years. And now we have this statute, and we've had him telling us, hey, I work for the governor, I don't work for you. And there had to be a resolution. And one thing I want to make clear is...
Well, and if I may, Mr. Watson, okay. So you pretty well answered my question in relation to your relationship with Mr. Mehdizadegan.
Well, and I recommended him to the board because I'd had multiple conversations with him. You saw today how intelligent he is, how quick he is.
Yeah.
And I went to him and I said, I've interviewed and I've hired attorneys for 24 years for different companies I work for. When I find the right one, I don't.
Okay.
I stop.
Gotcha. So have you, the two of y'all ever worked on cases together?
Nope.
Have you ever received a referral fee from Mr. Or your firm from Mr. Mehdizadegan?
No.
No? Okay.
No.
And Senator Dismang, you're recognized.
Yeah, so just to kind of go through the timeline just one more time, and I'll just ask for a date, and we'll just kind of say yes or no or whatever. So I think, on around November 9th is when you initially called Abtin, and in that conversation, there was no talk of employment.
No.
Okay. And then, you had conversations on and off again with
I'd hope that we wouldn't need to employ.
Yeah. But, well, I guess just to back up one more time. So when did the chairman ask you to find an attorney?
It was several months before that because I told him.
I think he testified in the summer.
Yeah.
Okay.
And
so in the summer,
it wasn't go hire somebody. It was start checking the field to see if there's somebody out there that was competent.
Okay.
And better than competent if possible and willing. Because, frankly, there's a lot of attorneys that wouldn't take this on.
Gotcha. Okay. And so then you had a couple of conversations since then, shared some pizza. Then there was a press conference on November 17th. Mm-hmm. He was part of the response that was given to the press conference. Was that made on November 20th? Is that the way I read it? I can't remember. I can't read my own writing.
I think that's
so. But anyway, he was a part of. What do we need to say and how would he need to say it? Mm-hmm. Okay. And at that point, up to that point, there was still no conversation of him coming on or being hired as an attorney. Is that correct?
Correct.
Okay. And then we get all the way to December 8th, 2024, and sometime between November 20th and December 8th, according to his testimony, you didn't ask him hey, would you be interested in being an attorney? He just happened to have one of his engagement agreements and he gave it to you. Is that how you remember that?
He did, and I don't remember just when, and I was still at the point, and I think the board was, of hopeful that we could resolve this.
But that was sometime before December 8th.
It was. I don't remember just when.
Okay. And so, but in that, you never said, hey, we may want to look at hiring you. Do you have an engagement letter? Do you remember it that way, or do you remember it his way, which was, I wasn't soliciting or even telling them they should hire me. I'm just going to give them an engagement letter.
I think at some point pretty close to December 8th that we had, that we did have a conversation, and I knew I couldn't hire him, that it had to be a board decision, and I made that clear to him early on.
When early on? Say that.
Gosh,
give me a date.
Like one of our first conversations, if not our very first.
So there was a conversation about employment. These are the questions I'm trying to ask.
Well,
was he aware that there was a possible, let me rephrase the question. I'm going to go back to the beginning. November 9th, 2023, you gave him a phone call. In that phone call, a minute ago, you told me there was no talk of employment. And just a second ago, you said early on in the conversations, I told him I couldn't hire him, that the board would have to hire him. When did that occur?
I think one of those first conversations.
Okay, so he was aware.
I wasn't hiring.
But he was aware that there was a conversation about hiring someone because you thought enough of the conversation to let him, or there was enough of a conversation, you thought enough of it to say, hey, by the way, I can't do this on my own. We'll have to go before the board. That's a very different thing than what you just told me. I asked, was there no.
Yeah.
I wish I was an attorney because attorneys are really good at something that I just can't do.
Sure.
And that is dance around and answering a question. And so my question is, did you talk to him about employment? Yes or no, on or about November 9th in one of your first meetings?
I don't think it was then. I think it was later. Because I told him at first, I'm calling you as a board member. This is just us. And somewhere in that process, over several conversations, I made him aware, I can't hire you. If that were to ever happen, it would have to be a board decision.
Okay. And so November 9th, somewhere may or may not have been right after that, there was a conversation about employment in which you let him know the board would have to hire him, you couldn't. So there was a bigger conversation of some kind because
somewhere in the middle between the 9th.
You wouldn't just set it out of the blue. And then so in all of that time, so from November 9th to December 8th, let's just say, was there any written communication between you and Mr. Abtin? Very
little. And I will tell you, in one of my first conversations, I asked him about attorney-client privilege and about.
Oh, no. You please don't tell me you did that.
Yeah.
You asked him about a clear. He just testified earlier that all he was doing was giving advice. You can't ask about it. I'm not an attorney. Some other attorneys are going to have to cue in here. But there is no attorney. He was representing that there was no attorney.
I'm an attorney also. We were just, it was. I didn't know. My concern was, what if I have these conversations with him and he goes public with them the next day? And at that point, I would have backed up and said, wait a minute, Benny, we can't do this.
I apologize, committee. I'm an attorney. You are, and I think you all that are attorneys probably need to hop in here in a second because there's things that you just said that conflict with what he said, and he stated things very specifically on purpose. You told me a minute ago there was no talk of employment. Then you talked of attorney-client privilege. Then you talked, and just prior to that, you explained to me that you told him you couldn't hire him, but the board would have to. So in all of that, I'm going to tell you, you haven't been very clear.
Okay.
And I think on purpose, but
no,
I'll leave it there. So let's just fast forward December 8th, okay? Because I was going to ask you about solicitation. It sounds like to me that happened. You all made a decision to then hire Mr. Abtin as an attorney.
Yes.
You went into an executive session to talk about the secretary. You went to lunch. That was a 30-minute executive session. There was no mention in the minutes otherwise.
Right.
There's been no mention anywhere else of a conversation about hiring an attorney in any of the minutes. My understanding, I guess it's happened through executive, which even though I don't think that's allowed to happen in executive. We've asked, other people have FOIA'd, there is no documentation of these conversations between you and Abtin. They just don't exist. There's no conversations between you and the chairman about hiring an attorney. There's no conversations anywhere to be found anywhere. Pizza, phone calls, whatever. But in that 30-minute meeting, you talk about the secretary, we're going to have to do something, you go to lunch, you come back, you meet for 3 minutes, and you have an engagement letter that no one else could have seen because we would have known about it because it had been foilable, right?
Yeah.
I mean, right. So no one else has seen the engagement. You've been holding on to it for a few days. Mm-hmm. And then in 3 minutes, y'all decide to sign that sign that engagement letter and move on. Mm-hmm. Do you do that in your business? We both know the answer is no.
My employer trusts me. And if I came to them and said, I found the attorney we need to hire for this job, they might, I mean, it would be.
There'd be some questions,
not
right?
Much.
You wouldn't I mean, I would say, how much does he want to charge? But that didn't even happen publicly. Right. There's no record of that in the minutes. Mm-hmm. It's just the fact, hey, we need to hire an attorney. Okay, I know this guy, Abtin. Okay, here's an engagement letter. Okay, let's sign it. And I'm not making it up. It's in the minutes. Mm-hmm. In a 3-minute span. So there was more conversation about needing to hire an attorney than there was actually hiring him. But without question, we moved on, which leads me to believe there were a lot more conversations taking place behind the scenes. And you said something earlier about FOIA. Mm-hmm. And there's reporters in the room that can speak to it more than I can, and I don't know. But if there are two of you having a conversation about board business, and it's written or whatever, and it can be produced as a document, that's subject to FOIA. Now, I've messed that up some, but generally that's the premise of how FOIA works. So it's not three for a public meeting, 2 is FOIA, okay? And just, you may want your attorney to talk to you. You're an attorney. You probably know how these things work.
I was thinking of the meeting. That's why I was thinking of 3. Because I know there are cases that say 2 people that are on a board can go have supper and be friends. And
that's correct, but you can't talk about board business, which I'm assuming y'all didn't do. I asked earlier, you didn't talk about board business at that lunch, did you? You didn't talk about hiring Abtin at that. Y'all just sat across from each other, enjoyed McDonald's or whatever it may be.
Yeah.
And then came out right after that and had a 3-minute vote on a $285 an hour contract.
Correct.
And you understand from my perspective when I look at this, how odd that all seems.
I understand. And the thing is, I'm the only attorney on the board.
I agree.
And,
yeah, okay, fair enough. I don't think you're the only at this point, but.
Well, and I recommended that we hire Mr. Mehdizadegan, and they trusted me and followed through on it. I mean, it's that simple.
Did you ever let him know that y'all didn't have an appropriation to pay him with?
Frankly, I didn't know that. And, and that's part of the awkward part of this, because you have the Board of Corrections, you have the Department of Corrections, you have the Department of Community Corrections.
Were you all aware that you were going to be suing your own employees, the Department of Corrections?
Well, and in part, that was Mr. Mehdizadegan's recommendation so that we wouldn't have to name the individual directors. And because those are the 2 positions that were affected by those changes.
Were you aware of how he felt about your employees?
In Act 659.
Were you aware of how he felt about your employees, that they were working to undermine you and what he was trying to accomplish?
Whose employees? I mean...
Well, I'm sorry. You're right.
I'm confused.
There's a differentiation between the board and the department. The department employees, Mr. Abtin represented a minute ago,
right,
or 20 minutes ago, whatever, that essentially that he was always concerned that the employees of the Department of Corrections were undermining what he was trying to do in the contracts and everything else. Were you aware that that was kind of his position?
To some extent, I always try to think best of people, and that they're trying to do the right thing. I think attorneys by nature become very suspicious of people, and I think it's a hazard of the job.
I'm not an attorney.
Yeah, and throughout my life, I've always tried to think of and expect the best of people. And I thought, well,
So you were the only attorney on the board.
Right.
He was only going to represent you and sue your employees over the Department of Correction, or that entity. Mm-hmm. And in that process, you didn't think that, and then there was already some reluctance. You were yourself, Abtin. Everybody kind of distrusts a little bit, but we're going to, try to hope they're doing the best thing. in the employees. And what I'm talking about is those that were, it's been alluded to that by several board members, well, it's the jobs of the employees to review this contract. Well, Mr. Abtin made it very clear that it was not their job because he was suing them. So how could they review that contract?
I know.
And then you were copied on the email. So now my question is, did you review the contract, the one that was ultimately uploaded?
I did not.
Even though it was emailed to you?
I did afterwards. And I was at work the day that I got that. I have a very demanding job. I normally don't check my state email. I work for a private employer. And I happened to look at it that day, and I saw that. I popped it open. I thought, and my gut reaction was, this is a form that has to be filled for procurement, because they'd already provided a copy of our engagement letter, which we considered to be the contract. And so if I had thought for a second, hey, this replaces or somehow modifies our engagement letter, I would have put on the brakes.
Were you comfortable with the changes that he had made?
After the fact, yes, I've looked at them and I'm 100% confident. Those changes weren't made for his benefit. They were made for the benefit of the board in our litigation that's pending, so that we didn't waive or give up any rights.
Well, the payment would have been for his benefit through an appropriation that doesn't exist for
Right.
you, that was going to come from the department that was actually being sued.
But he was representing us, and I believe every change he made was in furtherance of his ethical duty as an attorney to give us the best representation and make those changes, so it didn't look like between us as parties to that contract, it was harming us.
But I'm coming back. Thank
Go
you.
ahead. I'm sorry.
Thank you, Senator Dismang. And so were you aware, over here, in front of you, right here? Oh, Chairman.
I'm sorry.
So were you aware that Board of Corrections did not have an appropriation?
Not really. No, I mean, I knew that our appropriations.
When you say not really, what does that mean?
I mean, we had limited appropriations. We have staff. So, but, and earlier there's a lot of conversation about contracts that we review and approve. Those are for the departments. That's why they take them back and they push them through the appropriations process, and we're not involved in that. We approve of the contract. We review them, and trust me, we take them to task if we don't think things about them are the way they should be. But this was a unicorn. This was a contract to be signed by the board, and it was between the board. In 4 years, and then talking with Chairman Magnus, he doesn't remember the board signing a contract on its own behalf. But we were the ones being impacted by the statute and Amendment 33, and the department was indirectly. So this is a unicorn for us.
So
we've never had this situation.
So you didn't have a conversation with Mr. Mehdizadegan that there may be a possibility that he might not get paid?
Not initially. I think at some point I said, this is going to be difficult. Because we're fighting City Hall in some ways here, and it's.
Exactly. Okay. Representative Beatty.
Thank you, Mr. Chair. You said something just a moment ago, Mr. Watson, where you said all the changes that Abtin made on the contract benefited the Board of Corrections and benefited you. Explain to me and this committee how the waiver of sovereign immunity benefits you or the Board of Corrections. Explain that to me.
Well, can I give just a little background?
Whatever it takes to
Okay.
explain that so that we can understand that, because I don't think you're going to get there.
And if Abtin were here, to some extent, I'd defer to him on this. Because
I want you to explain it.
As Senator Gazaway touched on with the Andrews case, some of the sovereign immunity is unsettled law. There's some cases that seem to indicate that it really just applies to cases where somebody sues the state asking for money damages. That's not what we did. We don't want a dime. We don't want a penny. What we filed was a declaratory judgment action asking the court to say, between Amendment 33 and Act 185 and those two word changes in the PROTECT Act, are those constitutional? What's the law? Because we were sitting here trying to make a decision about an employment matter, but we're looking at this, I'm like, we don't know the answer. So if we tried to do anything, and we'd tried to communicate with Joe Proferi, and he wouldn't provide us information. We've only learned after he's gone the multiple contacts he had with other agencies regarding building a new prison. He never told us about any of those. And I asked him, in board
Okay,
meetings.
we're
But-
getting
but
away
anyway, I'm
from
sorry, I
my
got off
question.
track.
My question was,
Yes.
how does waiver of sovereign immunity benefit the Board of Corrections? You said every change he made in that document, because I'm not going to debate if it's a contract
Sure.
or what, benefited the Board of Corrections. He was looking out for you. How does that benefit you?
His concern, and I agree with him reading his changes, was that without those changes in the pending litigation.
I'm just talking about the change on sovereign immunity. How does that benefit the Board of
that
Corrections?
could harm us because the Attorney General could use that to claim, oh, their lawsuit should be dismissed because somehow sovereign immunity prevents it
I mean,
and blocks our lawsuit.
I still
which
don't
is
know
a-
how you arrive at that consideration, because I don't think that in any shape, form, or fashion that
Well-
benefits the state, the Board of Corrections. It
Yeah.
would only benefit payment for the law firm. So let's move on to another question, since we're on sovereign immunity.
Sure.
At what point in the discussions that you had with the attorney did sovereign immunity ever raise its head and y'all have a discussion about sovereign immunity?
I don't remember just when. It was before I ever saw that form or the follow-up. It was, he and I talked that in general terms about issues that might arise in the course of our, the declaratory judgment action.
Another question for you. I serve on several boards and committees, and a lot of times, and I see other members that when we're in meetings, they keep a journal or they take notes so that we can keep facts straight and follow things of the day and reflect on them at the end of the day. Do you keep any such records on our meetings, or do you just operate from memory?
Occasionally I do, but then I end up, I look at them later and I throw them in the trash. I mean, I don't keep them.
So you don't keep any written documents, records, or anything from your board meetings or anything like that? You don't maintain any of that? It's in and out?
Yes.
All right. Thank you.
And most of our business is very routine. We consider contracts, personnel issues, we make decisions. At the end of the day, on my cover sheet, I might put check marks, and there's almost, regarding everything we approve. I may glance at it later, but then I either leave it there and it's disposed of, or, when I get home, I put it in the recycle bin.
I find that hard to believe. Anyone that would write a 5-page open letter to the legislator, the governor, and attorney general, and doesn't keep any notes or details, I find that a little hard to believe. So I appreciate you.
Senator Hammer, you're recognized.
Thank you. I want to go back to the initial conversation you had with the attorney and get you to clarify something. And maybe put it this way, how could you have an interview with an attorney that you were tasked with the responsibility of going out to find to represent the board and it not come up in the discussion that could lead to possibly being hired?
As best I can recall, when things first started, there were issues that I didn't know the answer to regarding the conflict between the statutes and Amendment 33. I was looking partly for a sounding board, and I told him, I don't know where this is going to go. We want to work this out. And one of the things that Chairman Magnus had told me was earlier in the year, he had reached out to the governor's office a couple of times to try to, and through intermediaries, say, I would like to meet with the governor. And that just wasn't happening. And he had previously always, whenever he had done that, previous governors had always sat down and talked with him. And we just didn't know where it was going to go in November. And then all of a sudden in December, frankly, kind of the wheels came off and everything, we realized we have to do something, So it was further into that conversation where I really even got the feeling we may need to hire him for sure,
Okay, and then you made a statement a while ago I wanted to get clarification on. Did the attorney advise you to sue, or was that the decision of the board that made the decision to sue based on something you said a while ago?
We knew at that point that one of our directors, the director of the community corrections, was retiring early and leaving employment because of Joe Proferi and because of his treatment there and the morale he was creating with staff. We did not want to lose Jerry Bradshaw, but we did. And one of our considerations was, because in the lawsuit, it named Joe Proferi as Secretary of Corrections. And Abtin at some point said, well, I'm going to have to say Jerry Bradshaw as Director of Community Corrections because his reporting up was changed in the new statute. And we pushed back on that. And I don't remember, I did. Because I said, it's going to be offensive to them because their name's going to be out there in the press. Is there some other way we can do that? And anyway, his answer was, well, we will name the department. But our intent there was really, it was because of their position as director.
Okay, and so in that initial conversation you had with the attorney, the discussion of possibly suing was never in that initial conversation where you were interviewing him?
No, that didn't come for, weeks.
Okay.
I was trying to figure out for the board what our options were. This was like the last ditch op. What happened? We were trying to find some way to work this out. And unfortunately,
Okay. And I want to make this statement. I'll be done, Mr. Chair, on this, but you brought it up, so I want to respond to something you said about the morale and how you felt it urgent because of, what Joe did in his leadership role. I can tell you for a fact that prior to even Joe being hired, that I've been approached by multiple employees, both present and that have left because of the morale that's been created by the middle management of the agency, of the department. I don't think it's fair to lay it off on him, given the fact that the problem preceded him and even continues today. So I think I would be giving you free advice that maybe one thing y'all need to look at is the management, middle management of the system that's running people off.
That is very much on our radar. We talked about it at the last,
Okay.
when we were interviewing candidates for the Director of Corrections position last week, Director of Community Corrections, when we were interviewing, we asked them, the ones that would know, what do you see as a big issue, things that need to be fixed within the department? We already knew it, but, we were wanting to gauge what their response would be. And they said, morale, we have some issues here. And so we want to do everything we can to improve that.
All right. Thank you. I got off subject. Thank you, Mr. Chair, though, for that.
Thank you, Senator Hammer. And Senator Irving, you're recognized. Oh, we punched. Oh, yeah. Oh, I'm sorry. How about that?
Thank you, Mr. Chair. I've actually been watching all day as I've been driving around the state of Arkansas, or listening, not watching, as I've been driving down. So thank you, Mr. Chair, for the latitude to let me ask a question. I think one of the questions I had from the review subcommittee that was listed in this document here as our handout one, my question that I asked during that committee meeting was, how did the contract get interchanged and submitted through the portal? So that leads me to what was provided by Mr. Byers with his analysis. And in that, on page 3, and I apologize, I had so many things I couldn't get here before until now. But it says that under Mr. Magnus, it says, we believe legally standing we can pay the bill out of professional services. And that was what Mr. Magnus said, and that is in this handout. So you're the only attorney, or at the time, the only attorney on the board. So my question to you is, what led to the belief that y'all had, that the Board of Corrections had, that you believe legally standing, we can pay the bill out of professional services? Because that speaks to the appropriation issue
I know.
that the Department of Corrections does have a line item for professional services. So how did you, as a board, come to understand that line?
I'm not sure that we ever did. You know, the way that I looked at this,
Were you ever told that?
I don't recall. I just don't. But, you know, I believed, and I forget the entire code citation ending in 711, says that when there's a conflict between constitutional officer and the Attorney General and another constitutional officer, we're entitled to hire counsel, and they're entitled to be paid a reasonable fee. In Judge James' order, she agreed with us, and she said that under 711, we were justified, entitled, I forget her exact word, in hiring counsel. And that gave me a big sigh of relief, because I thought, okay, well, we have a statute that says we have a judge that says we're entitled to hire him, and the statute also says in the same sentence, and he's entitled to be paid a reasonable fee.
So we know that the Board of Corrections does not present before this body an appropriation request through the budget process, correct? Y'all have never done that. Y'all have never had an appropriation that's separate and apart. So who pays for your staffing?
I'd have to defer to Chairman Magnus.
Okay, so, but is it safe to assume that your staff is paid through the appropriation of the Department of Corrections?
I believe so.
And Mr. Brown is one of the attorneys. Is Mr. Hodges one of the attorneys?
No, they both work for the Department of Corrections.
I understand, but they
They don't
also
report.
advise you, right? I mean, all through this, Mr. Brown is working in the capacity as a staffer, so to speak, for the Board of Corrections. For example, we have boards all the time that may or may not have their own appropriation, but
True.
they're staffed by attorneys that are with either the Attorney General's office or other agencies.
And as Senator Dismang has pointed out several times, that's just part of the awkward part of this whole situation.
Right.
We've never had this happen before. Frankly, I don't think any of us really knew. You know, we were in uncharted waters.
Okay, but at some point, and Mr. Magnus may need to answer this because it was his statement, at some point, either y'all were advised that you could do this out of professional services, or somewhere you got that idea from.
Well,
Is that safe to say?
What happened after Chad Brown provided that memo in a board meeting, part of the open meeting, we talked with him about that, and you know, Chairman Magnus asked him to basically, you know, tell us what to do to how to process this, because in his memo he said there's two avenues, either what we've done,
Submit to Office of State Procurement, or
we tell him to go to the State Claims Bureau.
Right.
And this whole process, it's just, again, this is a unicorn. It's never happened before. We were just trying to basically follow through. We'd submitted his contract, the engagement letter as updated, and it was only, you know, basically a day before, in order to stay on the ALC agenda, we were provided with that form agreement. And none of us had ever seen it before. Benny says he's never seen that document before, and for any other purpose. Abtin hadn't, despite representing the state multiple times, and it kind of came out of left field. He was busy all that day. Like I said, I was.
I understand.
And I wish I'd seen it as something that might modify our contract, our engagement letter, because at that point I was like, whoa, wait a minute, put on the brakes. And,
right.
you know, and I do believe that Abtin tried to modify it so it would not conflict with that engagement letter.
Well, and that's the thing that I mean, I see blame kind of all across the board here, but I do think that if you have it should also be the attorneys that are submitting the information that, in my opinion, should say, hey, this is a red flag. We may or may not need to do this, or there's needed to be some sort of an advising role to the Board of Corrections, because you're not hired to be an attorney for the Board of Corrections. You
correct.
are an attorney who serves on the Board of Corrections. And so, I think we have to rely on that. And I think the procurement's probably more of an agency type of a tool versus what y'all are used to. So it's your testimony, though, because of this unique situation. Is that why the latitude was taken to change the procurement form so as not to kind of tie your hands legally because of the ongoing litigation? I think that's what somebody testified to earlier. I just wanted to hear that.
Yes, and when I read it after the fact, that's how I interpreted it. And especially when it became apparent, because we started getting feedback that, well, this somehow replaced our engagement letter. I'm like, whoa, wait a minute. No, I thought they would work in tandem. And when I read it, it's like, okay, Abtin's making sure that there's nothing in this composite agreement, if you will, that steps on each other. That we give up some rights or some issue by signing the form, which again was between us and him, or intended to be.
Right.
So.
No, and put any issue aside about however you view this whole situation. I think at the end of the day, it becomes a question of how and why. And I really appreciate the answers and the testimony that y'all have given as to how and why. But I don't know if I don't know if it fixes the problem for the legislature moving forward, or for the Board of Corrections. And I don't know how we rectify that, but I appreciate the transparencies and the questions that have been asked have been excellent questions by the members of the legislature, and I appreciate the answers as well. But
And may I comment on that?
Sure.
And thank you very much. But it begs the question. We have a statute that says if there's a conflict, a constitutional officer is entitled to hire counsel. That's what we did. We had a circuit court judge that says, yes, you were justified and it was good for you to do that. That statute also says that attorneys are entitled to be paid a reasonable amount. This happened basically on an emergency basis. So there's no time for bidding. There's no time for RFP. In the procurement world, so then how does that get addressed? Because that's the question.
And that's why emergency was put on the procurement form.
I believe so, because that's what it was.
Okay, and
thank you for the latitude. I appreciate
thank you.
that.
And if you can get back in the queue if you would like, Senator. So, Senator Stone, you're recognized with my apologies for knocking you out of the queue.
Oh, no worries. Thank you, Mr. Chairman.
Pardon me.
As litigation liaison, are you familiar with the claims in the two lawsuits, both of Amendment 33 case and the FOIA case?
Yes.
In which case has the waiver of sovereign immunity been raised?
I don't recall that it has. I think that's something that Mr. Mehdizadegan and I talked about being a potential issue. I don't recall it specifically in the pleadings. Granted, there's been a mountain of pleadings, hundreds of pages, and I think it's referenced in there. But again, I don't. Part of what I do is I review contracts, and I read sometimes thousands of pages a day, and I don't recall just.
Well, I don't believe that it has been raised, but if Mr. Abtin were to bring a lawsuit against the state to pay his legal bill, would sovereign immunity likely be an issue to be raised?
I think it potentially could be, yes. But then we have a statute that says in this situation he's entitled to be paid. So there's the rub. How do we resolve that?
All right. Thank you.
Thank you, Senator Stone. Senator Dismang, you're recognized.
And I think that statute's a little more complicated than you're giving it credit for. So I would recommend, again, I'm not an attorney, go back and read it. There's a couple of more hoops that you have to jump through before that. One thing I want to go back to, and I meant to ask it a minute ago, have you provided all the documents, anything that may exist with your communications with Abtin,
Yes.
with your communication with the board members? And so there's just really nothing then?
Yes. I mean, yes,
There's nothing.
I've provided everything that I possess.
But there's nothing, because I'd ask in the meeting, then we got nothing. Then I ask our staff to reach out and ask, and then they got nothing. So you're telling me that there was really no communication that was nonverbal, nonverbal between you and Mr. Abtin.
Very little. And unfortunately, that's reflected in some of his fee statements. And I know there have been articles written about my many conversations with him. And it's just I'm busy through the day.
I'm asking you, I'm saying prior to, I'm saying starting on November 9th, whenever you started having your conversations in which,
No, sir.
in one version of it, you said you didn't talk about employment. The other one, you talked about employment. That and all that, there was no correspondence between you and Abtin, besides phone calls or pizza.
None that I mean, if I had it, I turned it over.
Do you have his policy, which is, he stated his policy was to delete all communications almost immediately so that it doesn't build up in his inbox, but also because that prevents him having to be subject to FOIA.
I do, simply because of the volume.
So you delete all of your communications, and so if they're even worse, they wouldn't be available because you delete your communications.
Correct. Yeah.
Okay.
But at the time I've received any request, if I was in possession of it.
How quickly do you delete your things? How often do you do that?
Pretty quickly, and especially
Like, does that mean 30 minutes or like immediately? Someone text and I delete it out.
Usually it's
Immediate.
almost immediate.
Okay.
Yeah. And, it's.
Because that also just complicates this conversation we're having here.
I know.
Because you're anticipating me to believe that there was no conversation about employment with a man that wanted to be paid $285 an hour, that you go into an executive session, which you couldn't have talked about hiring him, that was called by Mr. Feltz, I believe, who then later, after that, after everybody goes to lunch, comes back, there's a 3-minute meeting, and then which we hire an attorney. So, none of the other board members had a conversation about Abtin. None of the other board members were even aware we were talking about hiring anyone until we go into a 3-minute meeting. Is that, and I'm supposed to, that's how that worked?
Pretty much, yes.
So
And
when he gave you his engagement letter, that you destroyed it also, the one that was unsigned?
I believe so.
Oh.
Yeah. At some point, it seemed like he gave me an updated one.
Oh, he gave you 2 engagement letters?
I don't recall for sure.
Over what period of time, do you think?
Sometime in early December, because it was, and I'm not trying to argue with you.
I'm not arguing, but I'm trying to understand.
When I said we inferred that we discussed employment, it was more like, I can't employ you. And, I want to talk with you.
That there was a conversation that had to be about employment.
Very late in the game.
Well, you told me a minute ago it was one of the first couple of meetings you had.
That was to tell him I couldn't employ him. And that we were not employing him. And I was not.
All right. So just to make sure I understand, there is no communication with Abtin to be had by anyone because none of it exists, or if it did exist, it's all been deleted. None of the other members knew that we were talking about hiring an attorney because if that had been talked about, it'd be somewhere there would have been a board minute that would have talked about hiring an attorney. So none of that exists. And then, so you brought all of the board members into an executive meeting, which we complained about the secretary and the things we was doing. Mm-hmm. We can't talk about hiring an attorney in that because that would be against the emergency session rules. And so then we come out of that, we go to lunch for however long it was. Then we have, in a 3-minute meeting, you say we need to hire an attorney. Everybody says yes. And then we say, we're going to hire this attorney. Everybody says yes, and we're done. And there was never any communication about that to be had or to be seen.
At some point there toward the end, I told Benny that I'd been talking to an attorney that I thought highly of, but no decision was made. It was just, because the idea was I was going to start looking around to see if there was somebody out there suitable. And my communication was basically to say, maybe, and if that becomes necessary. But it was not at the point where, Mr. Mehdizadegan had not been engaged. He'd not been.
Well, you'd already talked to him about attorney-client privilege. I believe that constitutes engagement. I believe, and I'm not an attorney.
Well, I think I brought it up in the context, I'm on a public board, and he said, well, it was a real simple conversation, because he said, as a public board member, there is no attorney-client privilege. Only the Attorney General has that. And if the Attorney General had been representing us as a board, we could have met with the Attorney General, we could have had multiple conversations, and none of that would have been FOIable.
Well, you were already meeting with Abtin prior to the Attorney General's press conference.
Yes.
Right.
We were talking on the phone, yeah.
All right. All right, look forward to asking some additional questions to the members.
Senator Hammer.
Thank you. When you were originally charged to go out and seek out an attorney, was the directive that you were given just to research, or to research with the intent to hire?
It was basically to research, to see if there was somebody out there that if we ever needed to hire somebody. Again, we didn't want to hire anybody. That was worst case scenario.
Okay. And so I just want to ask this question so you have a chance to respond, okay? It seems to me, and that charge was given to you in August, did you say a while ago? Ish.
Somewhere back in there, and it wasn't really a charge, it was just a conversation. Hey, if this gets off the rails,
okay,
you might want to look around and see if there's somebody out there. There was no plan.
Okay, so I just want to ask you, so we can get it on the record, was there any discussion, obviously unless you violated FOI, you probably couldn't have done this with any other member, but was there any discussion as to a strategy to stall this thing until it got to an emergency situation, to where it wouldn't have had time to run through the normal channels to get in front of ALC for us to approve
No, sir.
that contract?
No. This is, again, we would all much prefer that this had been resolved a long time ago. The board wanted the same thing the governor wanted, the same thing that this body wanted as far as the Department of Corrections. Because I think I didn't poll them, I didn't ask them, but I bet, when the governor and you guys announced basically, we're going to build another prison, we're going to add beds, you would have heard a round of cheers, because we all know that's what's been needed. It's been needed for a long time. And in my letter, I didn't mean to point fingers at the current legislature. This issue goes back to the early 1980s. And, we've had a continuing problem with capacity. And I get it. It's money. It's expensive. But no, trust me, if Benny had been able to talk with the governor early, we all would have been very ecstatic at the idea that this could have been resolved without any of this happening. I promise you I would. My wife would too, because I probably kept her awake a lot of nights, tossing and turning in bed, worrying about this.
Okay, all right, thank you.
Mr. Gasway, you're recognized.
Thank you, Mr. Chairman. Mr. Watson, thank you for being here today. I want to follow up on a question that Senator Dismang asked about the attorney-client privilege. It sounds like when you and Mr. Abtin were having these discussions, it clearly came up about whether or not the communications that you were having were privileged. Is that right?
No. The topic, and maybe I misspoke, it wasn't about them being privileged. It was about them being subject to FOI.
Right. And so Abtin told you in the course of these conversations that the two of you were having, that whatever you tell me, because you're a public board member, is not attorney-client privileged. In other words, it can be discovered, right?
Correct. Yes.
And I think the point is, if you're having a discussion about the attorney-client privilege, it essentially assumes that there is an attorney-client relationship.
Well,
otherwise, why would you talk about the attorney-client privilege?
We weren't talking about it, and I misspoke. We were talking about the FOI aspect of it. Frankly, I think one of my first conversations, I brought up FOI because I was I was concerned, one, if we managed to patch things up, I didn't want this, information out there to cause a problem. But it was about the FOI aspect of it, not attorney-client privilege.
So, it sounds like you were having regular conversations with him
Yes.
prior to the official hiring, and is it your contention that official hiring took place at the December 8th meeting?
Yes.
So, you absolutely were his client on December 8th, in your opinion?
The board became his client,
Yeah,
yes.
in your opinion.
Yes.
But prior to that, all the discussions that you had leading up to that, you don't feel like it at any point that through the research that he did for you, through the advice that he gave to you, through the very nuanced issues of law that you discussed about the Constitution, Amendment 33, and the employment matters, and all the things that you discussed with him, that at no point that ever ripened into an attorney-client relationship?
No. No, I don't. And, I've had other pending litigation where I've sought counsel from other attorneys, even though I might have had an attorney, or maybe not, where, I was trying to figure out the best course. And as a board member, I was trying to figure out what are we going to do if. And I wish I hadn't come to that. I really do.
Well, and, I'll go back to the point that has been made several times now. On day one, December 8th, the day that Abtin was hired after the 3-minute meeting, he spent 6 hours drafting a complaint. Mm-hmm. And he also included a couple of other hours where he specifically referenced conversations with you that day. The very next day, he spent another, I believe, 8 hours working on the complaint. It was somewhere around $4,000 in legal fees just on the complaint, which is a lawsuit. Do you see why it's hard for us to believe that all these conversations are happening? It's clearly involved Amendment 33 and the subjects of what were ultimately the lawsuit, and that somehow you weren't, and the board really wasn't his client until December 8th, and he just happened to start drafting a complaint on that day. You see why that makes it hard to believe?
Again, best case scenario, we wouldn't have had to do that. And he would never gotten paid for a dime of that time up until December 8th. And he didn't get paid a dime for any of his time up to December 8th. I didn't give him a penny. To my knowledge, no one else did. So, we had quite a few conversations, and he was very engaging. And it was obvious he saw this as an academic and very unusual situation, but of a constitutional nature and an employment law. And it's one of the things that really engaged me with him and made me think, okay, this guy's sharp. He's very sharp. He got the issues very rapidly, not pretty rapidly, but very rapidly. And,
So, and I appreciate that. And we're going to talk about payment for his services here in just a minute. But, I find it hard to believe, I think members of this committee find it hard to believe that all of those conversations that were taking place about these very specific areas of law, and then the day he's hired, he begins drafting the lawsuit against the state, that those communications did not ripen into an attorney-client relationship at some point prior to the day that you had your board meeting. But we'll set that aside. The sovereign immunity issue. Actually, no, let me go back. So the hiring of Abtin, let's talk about the 8th.
yes, sir.
Because you've been having these conversations with Abtin. The 8th, in your mind, is when he officially became your attorney. But there were a lot of other law firms that you could have contacted here. I mean, I mentioned several of them earlier. You have the Rose firm, you have the Friday firm, you have Mitchell Williams, you have Wright Lindsay Jennings. You have a lot of really good law firms here in Little Rock that do employment law. Did you ever talk with any of those firms?
I did not, but when you say those names, as an attorney who's hired counsel to represent companies in personnel matters, all of those I see as big dollar firms, expensive firms. And one of the things I noticed about Abtin early on, it was a smaller firm, at least smaller footprint here. And, my experience, the larger the firm, the bigger the bills. And one of the things that subconsciously factors in with me is I want the best for the best price.
Okay.
So,
All right. Well, let's talk about the contract that was ultimately submitted in March and the issue of sovereign immunity. So I noticed when I look at the contract, a few things that I find very interesting about it. The changes that Abtin made to the contract, specifically in Section 5, he added language about that he was to be reimbursed expenses incurred during the representation, and he added $7,000 to the bottom line of the contract. It was $200,000. He made it $207,000. Did you know about that?
not till after the fact.
Okay,
But that's normal in engaging counsel. They very often itemize business office expenses.
But my point to you is, let's take that aside, and I understand that. But one, that's about money to Abtin. Okay, right?
Sure.
All right. He went on that the board's litigation liaison, which would be you, shall be solely responsible. Now, you're the guy he was having all these conversations with before this contract was submitted, that you would be solely responsible for determining whether or not his performance was satisfactory. Mm-hmm. Well, that's quite convenient, isn't it? I mean, you're the one he had the relationship with, and you're the one who's hiring him, essentially recommending him to the board. You're the sole person who's going to determine whether or not his performance is satisfactory. So that, and then as it continues, and the litigation liaison, of course being you, shall be responsible for authorizing payment under this agreement. Again, he's adding provisions that were not in here previously that relate to him being paid, and changing the terms of the contract by $7,000 for him to be reimbursed expenses. Mm-hmm. Were you aware of that?
Not until after the fact.
Okay.
But again, I look at those, if I can explain, as, I was his contact, his go-between with the board, and I looked at his fee statements, and if I had issues with them, I would have rejected them. And I've done that with other attorneys I've hired. If I think they're billing excessive, that's...
No, I understand that. And I don't want to get too far in the weeds on that, but I'm heading to a specific point.
Sure.
One is then that particular paragraph, paragraph 5, all the changes made there benefit Abtin. It was $7,000 more money to Abtin. It was you reviewing his performance and you being responsible for paying him. It's about money to Abtin, okay? Let's go to paragraph 5. That's where he reflects the $7,000 increase to the contract to $207,000. That's a benefit to him. Let's go to paragraph 9, sovereign immunity. This portion of the contract has written in bold and in red letters, non-negotiable. Okay? And the point is, this provision states, nothing in this contract shall be construed as a waiver of the state's sovereign immunity. And in this particular point, Abtin adds a change, if applicable. Okay? And then it goes on. Any claims contractor, that's Abtin, wishes to assert against the state in connection with this contract, in other words, to be paid, shall be brought in the Arkansas Claims Commission, and then Abtin makes another change right here, if applicable. Mm-hmm. All of that is to benefit Abtin in order to get paid. Wouldn't you agree?
Well, I think, if I can explain, the first one has to do with sovereignty generally.
But do you see a distinction between the issue of sovereign immunity and the issue of Abtin being paid? And I think that's what Representative Beatty asked you about earlier. Mm-hmm. The point is, sovereign immunity is not an issue in the Amendment 33 case, correct? Never been raised by either party, the issue of sovereign immunity in the Amendment 33 case.
I will tell you that personally, I didn't fully understand that issue, but Abtin explained that it could be. This was before we ever even saw this document. But then regarding the Claims Commission, We have a statute that says we're entitled to hire him and he's entitled to be paid. So, it's like, well, does that conflict with what Judge James had ordered and Section 711?
Again,
You know,
Mr.
it-
Watson, I want to ask the question. I've asked a very specific question. I'm going to ask it again. Has the issue of sovereign immunity been raised specifically by either party in the case related to Amendment 33?
I don't believe it has, but
Okay, now let
Abtin
me
has
go
told me
on.
to expect that it would be on appeal.
Has the issue of sovereign immunity been raised by either party in the FOIA case?
Not that I recall.
And so, once again, there is really no distinction in the issue of sovereign immunity, or there is no issue of sovereign immunity in any of these cases that Abtin is representing you on the board on, other than as it applies to his ability to be paid.
Well, no, I disagree. I mean, he's told me very clearly that very often it is raised for the first time because it can be, because the Supreme Court has original jurisdiction on sovereignty issues.
Okay,
Even if it's never raised at the lower court level, the Supreme Court can say, yep, this lawsuit dies because of it. And he
Well-
wanted to make it clear that we weren't voluntarily giving up any ground there.
Okay, fair enough, but let's talk about specifically the language in paragraph 9. Any claims contractor. This isn't about what the Supreme Court can do in the Amendment 33 case sua sponte if they decide that sovereign immunity applies and the whole case should be dismissed. This is about any contractor. Who's the contractor? Abtin. Any claims Abtin wishes to assert. This is about Abtin. This isn't about the board. This isn't about Amendment 33. This isn't about the legal doctrine of sovereign immunity and how the Supreme Court may interpret it. Any claims contractor wishes to assert against the state in connection with this contract shall be brought in the Arkansas State Claims Commission, comma, added by Abtin, if applicable. That's all about him being paid.
Well, and it's about the conflict between that and Section 711, which says if we're entitled to him, he shall be paid a reasonable fee.
Okay. Let's go on. Another change that he made in paragraph 15 of the contract, which is specifically about amendments. It says, the terms of this contract shall not be waived, altered, modified, supplemented, or amended in any manner whatsoever without written approval of both parties. Any amendment that, and so this is the pertinent part, any amendment that increases compensation. What are we talking about? Compensation. Or represents a material substantive change may require review by legislative council or the joint budget committee pursuant to Arkansas Code 1911-265, and Abtin added, comma, if applicable. The point being, an issue about compensation, who does that affect? Abtin. May require review by legislative council or the joint budget committee. Does he want that? No. So what does he do? He adds the language at the end of that, if applicable. Do you see that all of these changes all relate to issues about Abtin, his compensation, and his ability to be paid? Do you see it some other way?
I do. I disagree because I think it's, again, about even the inherent conflict there between that and 711 and how he is paid. You know, even Chad Brown, I mean, everybody said, well, he's put in all this work. He deserves to be paid. The question is, under 711, how does he get paid? Okay. And that's why we're here. We thought we were doing it the right way. If we weren't, we need to start over.
I'll keep going. Paragraph 19. He made changes, one of which at the very end, which is in a different type font than the rest, outstanding invoices in line for payment. Once again, and I think the point is, these changes were made very inconspicuously, I might add, although one was in a little different type font, and submitted, and it sounds like when you guys first appeared before ALC, that no one knew anything about them. I mean, is that not concerning to you?
You know, it's my understanding that Chairman Magnus, as he testified earlier, pulled over, reviewed it. Frankly, I have almost no experience with procurement in that side of the house. I viewed this not as a replacement of our engagement agreement, you know, but again, I looked at it for a matter of seconds, the original one, the blank one. And, you know, I thought this is just an explanation of what the services are that Abtin, that we have to follow through in order to get him paid. Now, in hindsight, after I read it, it's like, okay, well, this could potentially alter our legal relationship with him, our contractual relationship. And when I read it, I'm like, okay, now I get it. I know why he made these changes, and I agreed with him, because I would have if I'd been him.
Does it bother you that he made changes to a section of a contract, a standard form contract that's used by everyone who seeks to do business with the state under a services agreement like that he made changes to a portion of the contract that in bold and red says non-negotiable?
In any other circumstance, I'd agree with you wholeheartedly. But this is an intra-government conflict and decision that has to be made. So this is a unicorn. We're in uncharted waters. And again, we're trying to do the right thing by you guys, by the Constitution. We were in a position that was untenable. I mean, we're like, what do we do here? We've reached out to the governor's office. We don't hear anything back. We're publicly lambasted. And we can't manage the secretary. And then after Act 659 would go into effect, we won't even be able to manage the directors. So we're the board of basically upper management of a corporation, if you will, that we can't affect. We can't, they're no longer be responsible to us. And it, frankly, is a horrible position to be in. It's like, what do you do here? We can't continue. As one of the board members said a couple months earlier, we're quickly becoming the board of nothing. We had plenty of other issues, just with the day-to-day when it comes to trying to fit more beds in, trying to hire staff. We've tried to hire staff. Anyway, we have so many things we wanted to be focused on, need to be focused on, and here we're, all of a sudden, what we were seeing we thought was very poor, very reckless decisions to cram people into facilities that weren't ready for them, that didn't have adequate staff. And the results there could be catastrophic.
Okay. And again, thank you, Mr. Watson. I appreciate you being here.
But Senator Gasaway, I wish there had been another solution to this. I really do. The whole thing. We all do. The state would be better for it. I promise you, as a board member, I can't speak for everybody else. We need more beds in our prisons. We need in the existing ones, but we got to have staff for them. We need more prisons, and we all very much respect the PROTECT Act. I do. I used to be a prosecutor a long time ago. I was a public defender also, and we realize there's got to be consequences for people's actions. I live across the street from a woman who her mother and parents were killed years ago. And in a home invasion, and those sort of issues are very near and dear to me.
Thank you. And Mr. Gasaway, you finished? Okay. Real quick before I go to Mr. Beatty, a little bit of housekeeping. We're going to try to wrap up here in a few minutes, but we're going to recall one witness for just a couple questions. So with that being said, Mr. Beatty, you're recognized.
Thank you, Mr. Chair. There are so many things you said that I want to take issue with, and I'm still hung up on the sovereign immunity side as to how that would benefit the Board of Corrections or the state. I mean, I just don't see that, and I don't see how any agent of the state could sign an agreement and waive sovereign immunity.
Well, I don't think it did that. I don't think it has that effect. It says they will not waive it, if it's applicable. Well, as Abtin said, it's either applicable or not. I'm not as nuanced an attorney and a student of constitutional law, and that's something we as a board relied upon him for, his guidance and advice. I'm not a constitutional law expert, definitely not on sovereign immunity, and frankly, we had to rely on him.
Well, it is a big hang-up, and I think it was a hang-up with every member of this committee that read that.
I understand.
And it points out everything that Representative Gasaway pointed out in amendments to that contract or into the agreement. We won't call it a contract. We'll use whatever vernacular was used earlier. That only benefited the law firm. The other thing I take issue with is we named some fine Arkansas law firms that are here in the state that could have helped. I know Hall, Booth, and Smith has a presence here, but are you aware that they're in 12 states and they have over 400 attorneys on staff? And you referred to them, well, they're a small boutique type law firm. They're one of the larger firms in the country.
That was my first impression of them, and really until I dug into it further, I didn't realize that. And that's become so common with so many law firms, you know, frankly, because big law firms are buying the boutique firms all over the country. It's not good for the legal profession, but it's what's happened over the last 20 years.
And then I go back to the initial meetings that you had and your position and authority that was bestowed upon you by Chairman Magnus to be the legal advisor to the board and to seek out someone to deal with a personnel issue, when it really comes back down to everything I heard you say sitting at that table today goes back again to a 5-letter word I said earlier, and it's power. And that the PROTECT Act diminished the power and the role that the Board of Corrections and its members would have over the Secretary of Corrections.
Well, Act 185 did that.
Well,
yeah, which is not
correct.
part of the Protect Arkansas. I don't
separate
think.
act.
It's Act 659, but it does beg the question: if that's the law, which Judge James says it's not, Act 33 trumps those. If that's the law, then you know we as board members might as well pack up and go home.
So
there's going to be no service that we can provide.
So we're in this all because you didn't have control over one person that I think argumentatively we'd say you had control over, and you said you didn't want to be in this. You just wish we couldn't be in this if there's anything to do. Yet how many times and how many members of that Board of Corrections reached out to the governor's staff, reached out to the Attorney General, or tried anything other than going out and lawyering up and suing to try to declare this act unconstitutional so that you could protect your power and your fiefdom? What actions did you take besides hiring an attorney?
I know that Chairman Magnus told me that he...
I'm asking what you did, other than your open letter that was rather insulting.
Well, I also wrote a letter to the Attorney General as a follow-up to some of his FOI claims, and in it I asked him, we need advice. We need your counsel. But by then, everything was so awkward because of the position we had been in, and we were just trying to find a way out of that because, yeah, Amendment 33 vests general management powers over the board. And so if that's, from an attorney's perspective,
I appreciate your position. I appreciate you trying to answer the question. You know, the deal is it all comes back down straight to power. And the position and action you've taken as a board was to protect your power. And I think that's a dang sad state.
Sir, our goal was to protect the Constitution.
Thank you.
Thank you, Representative Beatty, and Senator Dismang, you're recognized.
Thank you. There's a couple of things, just because I know we're closing up. And was there at any point prior to the hiring of the attorney that you sought counsel from your own legal counsel or anyone else in the office about what action to take, how to pay, and all those sorts of things?
I don't think so.
I don't either, because it would have been almost impossible to happen in a 3-minute window. And so there was something said earlier, alluded to, and I want to make sure everybody understands really quick. Mm-hmm. Your staff did not get you into this situation.
No, sir.
And in fact, your staff or your department is being sued by you, which even complicates the matter even more. And to their own credit, they're trying to figure out how to bail you out of the problems that you've created. And that's why professional services came up, because they know there is no vehicle, because you didn't have the authority to do what you did to begin with, because you didn't bother to ask for advice before you entered into the legal contract. Now, there were 2 members of your board, and it's, maybe Mr. Giles comes or not, that decided that maybe this wasn't the wrong path. I look forward to hearing why. But anyway, so before we leave, I just wanted to make sure, I don't want anyone to be confused when we walk out of this room. The staff had nothing to do with why people are here testifying today, because they weren't even involved in the process of the discussion, how we got here. They've just been trying to pick up the mess. One thing you did say...
May I clarify? I mean, we did look to their assistance. Because,
After you made your decision to enter into an engagement.
correct.
Thank you. That's picking up the pieces after the mess is created.
Okay.
All right, and then on FOIA, you said something. So you told, there was a conversation about how attorney-client privilege was discussed, and essentially Abtin had said, that won't apply to us because you're a board member. I just want to make sure you know. And to which you said, well, that wasn't, and then you corrected, after some other questions, you said at one point, well, that was more about FOIA. I just had some questions about FOIA because I didn't want this to be subject to FOIA.
Well, it wasn't that I didn't know.
What a thing to say.
No.
No, sir. The fact that you were intentionally asking an attorney, how do I prevent this from being made available to the public? And you were having those discussions after probably, 20 minutes ago, you told us that you intentionally delete all of your texts and all of your emails so they're not subject to FOIA, which brings me back to the whole point of my problem that I've had the entire day. And that is, I do think there were processes in place. The process were to make sure that no one could follow the process. I mean, all day long, I've heard conflicting testimony back and forth. Why do we have conflicting testimony? Because nothing was done in the open. The only open thing that we have to talk about a $207,000 potential bill for the state of Arkansas, is a 3-minute meeting in which someone was hired. That is my disappointment. My disappointment is, I think that a lot of this was intentional. I think you've acknowledged in some ways that it was intentional. And I get that maybe you've said something that you didn't really mean to say, so then you try to fix it with something else that you probably didn't mean to say, and now we're about to probably give me some other answer that you don't mean to say.
No, sir. My concern was, I just frankly did not know if my conversations with him.
Well, you said a minute ago you didn't want them to be.
No, if I
yes,
said
sir,
that,
you said it twice.
I didn't mean to. Was not my intent. I frankly just did not know when I started talking with him.
You said you didn't want them to be because you thought if this whole thing could get smoothed out, you wouldn't want other people to know about the conversations you'd been having.
Well, my concern was, if we're exchanging drafts or ideas that are in their infancy that may change. And so that's why we pretty much decided we're just going to, communicate over the phone. And because I didn't know what the solution was. And frankly, I don't think he did. It's like, we've got this problem. We wanted to find the easiest, most, the best way.
I got it. We don't need to talk about the fact that there was talk of employment because that would constitute a relationship. We don't need to talk about the fact that we talked about the fact that there might be a relationship that would be subject to FOIA or not be able to be protected from clearance. I get all of those things. He was very careful in how he made his words earlier for that very reason. And again, I wasn't smart enough because I'm not an attorney to understand why. I do understand now, based on your testimony, why he was saying what he was saying. I'll leave it at that. I'm just disappointed in the process. I'm disappointed to think that you think we're naive enough to think that there was a 3-minute, conversation in which we hire an attorney at $285 an hour from a boutique law firm that turns out to not be a boutique law firm.
Thank you, Senator Dismang, and best for last, Senator Irving.
Thank you. This was, again, this was January 31 of 2024. So again, after the fact, just like Senator Dismang said. So Mr. Brown said something to the fact, or on page 4, if we need to go back and fix the way that the contract was established, then that would be my recommendation. That's what he said in this meeting. And then you responded that you do want to make sure that we follow the procurement rules and that the situation is a little different from other situations. So at that point, are you talking about, is he referring to, was the way the contract was established, and we need to go back and fix the way it was established? So is that in reference to the way y'all voted on the contract, or in the letter of engagement versus versus what we have here? I just need clarification.
What I was focused on is should we've even submitted that procurement document? Was that the right path?
Okay.
You know, up to that, I believe we were 100% justified under our statutes of hiring Abtin and moving forward. But frankly, we didn't know what we needed to do to get him paid.
So that was to produce the procurement
Yes.
document contract. Okay,
Yes,
and
ma'am.
then okay, I just needed to get that clear in my head. And then and this may be more of a question for Mr. Brown, but because we're talking about, but you do come into these emails where it says Chad Brown called Lee Watson to get the total anticipated cost, and that you directed Chad to contact Mr. Mehdizadegan for the information. But the word anticipated cost, did the board understand that this was an anticipated cost? Because that language is later used in an email from Mr.
And that's-
Brown as an anticipated cost of $200,000.
I think that was his reasonable best effort of what it would be to see this through. And what I'm used to doing is in-house counsel, the financial folks will come and say, hey, we've been sued, you hired an attorney, you've given us an estimated budget because they've got to book it. And initially I might say, okay, we may be able to get out of this. It may cost us a total of $30,000. Attorney's fee, settlement, whatever. If
Okay.
it progresses, then I have to go back to the business and say, you know what, this is taking a turn left. I think now our exposure here, because we did some things wrong, or whatever factors might come in, or it's in a city where the council's much more expensive. You know, we need to book a potential expense up to $100,000. And that's
Right.
what I saw this as, was not, it's gonna cost $207,000. I saw it as, this is gonna cost up to that.
Right.
And frankly, when we started this, had there not been such heavy pleading practice, and had there not been the FOI suit, I never thought we'd hit $70,000. I thought we would get in front of a judge, we'd get a decision on a declaratory judgment action as the constitutionality of this. If it's appealed, sure, that's gonna cost more. But even that all, I didn't think would, if you ask me, I just would not have expected that to go north of $70,000, even at $285 now.
Right. But I think, the problematic part of it is that the board there's no minutes that we can point to that gives the authorization of up to $210,000, $250,000. There's nothing that we can point to that gives that authorization, which is why there's an issue with the contract that's submitted. I mean, that's one of the issues, but there's several. But there was no follow-up board meeting after this one to give that necessary authorization.
I understand.
Okay, thank you.
Thank you, Senator Irving. And with that being said, thank you, Mr. Watson, for being here today. You're still subject to being recalled.
General Barry?
Yes.
I have a doctor's
Oh.
appointment in Northwest Arkansas next Tuesday.
Okay.
Something I've been waiting on for a month. It's with a specialist. If I miss it, it's going to get pushed off another month or so. And, hopefully, anyway, I don't know how serious it's going to be.
Yeah, and I think we've pretty well got you covered, so go ahead and keep your doctor's appointment, okay? Thank you. And the chair calls Mr. Benny Magnus back to the table, please. And Mr. Magnus, please remember you're still sworn in and under oath. But if you would, take a seat, state your name and position again for the record.
Benny Magnus, Chairman of the Arkansas Board of Corrections.
Senator Stone, you're recognized.
Mr. Magnus, earlier you testified that neither you nor your businesses have recently done business with the state of Arkansas. Is this correct?
Yes.
You are the current president and registered agent for Magnus Oil Company, correct?
Magnus Oil Company is still a corporation, but I sold the assets and closed down the entity in January of 2023.
If you go to the Arkansas Secretary of State's website, it still has you listed as the president and a registered agent. If you go to the transparency website, you'll find that Magnus Oil Company is listed 12 times doing business with the state of Arkansas. Is this correct?
I don't know in what manner, because I've not done business with the state of Arkansas as with Magnus Oil Company. And
Well, if you've sold
the only
it,
time that I can recall is the time that we got an exemption from the DF&A to try to get fuel to the farm. And if it says that, somebody's going to have to show it to me, explain to me, because I have not done business with the state of Arkansas as Magnus Oil. I haven't sold any fuel unless
well, if
even
you've
my
sold it,
retail.
why are you still listed as president?
Do what?
I said, if you've sold your business, why are you still listed as president?
Because we sold the assets. We didn't sell the corporation.
Do
And
you still benefit financially from that company?
Do what, sir?
Do you still benefit financially from that company?
I've benefited from the sale, but there's no longer any action in that company, and we haven't filed the final IRS return and done a dissolution. I can't remember the form with the state of Arkansas closing that corporation out, and we're just waiting for the final return to be done, and then we'll file the dissolution. So Magnus Oil only exists now as a entity for accounting purposes only. It doesn't make any sales.
What about other companies that you may be affiliated with directly or indirectly that are doing business with the state of Arkansas?
The only business I can think of that might be doing business with the state of Arkansas is I'm involved in Magnus Hospitality, and I have 7 hotels, so they could possibly someone stay there and as a state employee, and I wouldn't really know that.
I believe you're also still listed on the Secretary of State's website as in good standing. So I'm just wondering why all this stuff is still existing on the Secretary of State's website if you've sold it. I mean, I just need to get some clarity on what's going on, because what you testified to earlier and what's on the website is not adding up.
I would like to know where it shows in transparency that I sold
You can
state
go
of
to
Arkansas any services or product, because Magnus Oil Company has not sold anything to the state of Arkansas, to my knowledge, in 25 years, because it was known that I couldn't, except for the time.
You know you're under oath.
Do what, sir?
Yes, and you still realize that you're under oath on what you're saying
Yes, sir.
right now. Okay.
I just said that I realize, that I know. And Magnus Oil Company itself has not been in business of selling products since January of 2023. Magnus Transportation existed from up to August 30th of 2023. That has also been sold, and that also we're trying to close that corporation out. And so, I mean, I'm welcome to see any documentation or anything that would say differently than what I'm testifying to, because never in my mind in 25 years.
Well, I bring the matter up because it's still listed on the Secretary of State's website. And
yes, sir. And it will till we do
it. It'll come out one way or the other. Thank you, sir.
And thank you, Senator Stone and Mr. Magnus. You're excused with the subject being recalled.
Okay.
And thank you, ladies and gentlemen, for your patience today. It's been a long day. I just have one quick thing that I want to read for the record. And the next JPR meeting scheduled to be take up the Board of Corrections investigation will be held April 11th, 2024 at 1 p.m. in this room in Big Mac Room A. Please note we are providing notice to the committee members that that at the April 11th meeting, the committee will discuss whether any subpoenas need to be issued by the committee. This serves as the 1 week notice to the members of the committee as required by the law. That consideration of the issuance of subpoenas will be taken up. And with that being said, no further business. Well, let me yield to my co-chair. You have any comments, Senator. Thank you, Senator. And with that being said, this committee is adjourned.